welcome Officer Alan Rodriguez as well as Officer Jose Antonio Rodriguez from the U.S. Customs and Border Protection, who will be giving you their first presentation today. Officer Rodriguez, welcome.
Good morning. How are we doing today?
Great.
Well, I just want to make sure that I want to let you guys know. I'm been looking at the chat and I see a lot of people, a lot of locations. Well, I'm located in Miami, Florida. I know it's really hot out here. Not trying to brag, not trying to say anything. I've been with CBP for the last 16 years. I'm currently the supervisor in charge of export control in Miami International Airport. I understand that there might be a lot of questions. Please let me finish the presentation, and once we finish, I will be more than happy. I will stay to answer every single question there is, and if I cannot answer it because of time, they will provide me the questions, and I would provide the answers, so that way it could be disseminated for everybody here in the chat. Okay. So as they were already told you guys, I work for Customs and Border Protection. I'm in charge of the export control facility here in Miami International Airport. Our mission is pretty simple. We are safeguarding our nation's border. We're the front line for the America. We safeguard the American homeland and beyond our border. So that means that we here in Miami, we here in the United States, but we are at different locations outside the United States. We protect the American public against terrorism and instrumental terrorists. That's one of our main functions. We enforce the laws in the United States while fostering our nation's economic security through lawful international trade and travel. Our main, I would say, mission is to make sure that travel and commerce flows through our nation. Believe me, we're not here to try to stop you from sending things outside the United States or importing things. We're here to make sure that everything is good to go before we let it go. Can everybody hear me? Because I just saw somebody say no sound. Okay. We serve the American public with vigilance, integrity, and professionalism. And that's something that we strive here at Miami International Airport. I'm sorry? Can you hear me better now? All right. So what's the objective of Exodus? We prevent weapons, weapon components, and control commodities from falling into the hands of terrorists or criminals. We enforce U.S. government agency laws such as the Department of State, Department of Commerce, U.S. Bureau of Census, and Office of Foreign Assets Control. Many times we get phone calls asking us who's holding your cargo. Most of the time it's not us. We're just making sure that everything is according to the laws before we let it go. We interdict on reported currency. We process and clear vehicles export. This is a big thing within the Miami area of responsibility. We have a lot of vehicles that are being exported. It's a different, like you guys know already, is a different way to do things when we talk about vehicles. And we're right now looking into how we can incorporate that process to 2024 and beyond. And I will talk about that a little bit longer later on. Halt and encounter illegal hazmat export, EPA and Department of Transportation. They're the ones that regulate anything related with hazmat. We just a third party that we actually gonna put it on hold, look into it, and once we get a yay or nay, then we let you guys know. Facilitate trade. That is my main mission here at Miami International Airport. We have a new assistant port director, and we're really looking into how we can facilitate trade by incorporating new technologies and new ways to do business. Why CBP? Well, why us, right? Well, we're the only agency that has border search authority to enforce export control regulations. We are actually physically at the border, so it's gonna fall on us. And we have the authority to detain and seize merchandise being exported without proper license authorization given by Congress. So we're the only ones that can regulate that when it comes to exportations. We have to follow all the agencies, but however, we're the ones who are gonna regulate it. Okay, what is our role in the export environment? We enforce U.S. government agencies' laws and regulations. We enforce sanctions and embargoes against persons, groups, organizations, and countries imposed by the U.S. government. This is a really big topic. As we all know, there is a lot of countries that have been sanctioned, and there is a lot of people that have been sanctioned lately. and the embargoes because Ukraine, the war between Russia and Ukraine, all the things in Venezuela, Cuba, Iran. We will always look into that. We would, we have the Exodus department that actually help us with that. Just the only thing we ask you, I know that the process takes a little bit longer sometimes. Just bear with us. Believe me, we're trying our hardest to get everything done as soon as possible. We're gonna inspect the outbound cargo, passengers, and export documentations. We're gonna interdict dual use commodities, sensitive technology, narcotics, contraband, weapons, unreported currency, stolen vehicles, and other illegal exports. We're always gonna look into that. We will always strive. We're actually striving to have an 100% rate. It might be impossible, but we're trying. We're gonna seize anything that is in violation of the export control laws. All right, so why did I say it? Bear with us. Right now, in the Exodus Command Center, we only have one CBPO officer who is our, I would say, liaison with every other agency, and she works really hard to try to get everything done within 2 to 3 weeks, okay? But remember, sometimes we have to send it to multiple agencies for clearance. So Ms. Lopez is always, in communication with us and with me and the officers to try to get this done as soon as possible. AES, Automatic Export System. We all know that it's operated by CBP to collect commodity and transportation data. The trade community files electronic exportation information, AEI, per the filing time frame that varies depends on the type of commodity. So remember, some of them vehicles has to be 72 hours. Once processed by CBP, and during the air, is 8 hours for licensable and 2 hours non-licensables. Remember that EEI is then used by multiple agencies to produce trade statistics and enforce U.S. export control laws. I'm going to say something even more than that. The more you write in the EEI, the faster we're going to make a determination if we're going to let it go or not. That's the way you're going to tell us what's going on with cargo. It helps us a lot. And try to be as precise and try to help us when it comes to not just the description, but the weight and things like that. It's really important that we get that. And I understand you go based on whatever they give you, but we need that help. Electronic version of the shipper exportation declaration is the electronic export information. Transmission of the electronic export information is submitted by the U.S. principal party of interest, exporter or manufacturer, or authorized agent into the automatic export system. So when we're talking about the sea, you have sea cargo, you have 24 hours prior to loading of cargo. With air is 2 hours for non-licensable and 8 hours for licensable prior to export. As you can see, that doesn't give us, the officers, a lot of, the time window is not that for us to make a determination. So that's why we ask you to be as precise as possible. AES generates an internal transaction number, ITN, which we're gonna use for everything else. Submitted when value of the shipment is over 2,500, or if a license is required for export by the Department of Commerce. This is something really important for us. A lot of companies, they think that it's under 2,500. I don't need to file it, but they fail to look into the fact: is it a licensable commodity or not? Does the Department of Commerce gonna require a license? So do your homework before you do all the paperwork. If you have a question, reach out to us. We're more than happy to guide you to say, listen, you might need a license for this. Look into it. Or look, make sure that the price is, more than 2,500 or no, or not. Because the problem is sometimes we open the boxes and it's completely different what it was declared. If merchandise is subject to international traffic and arms regulation, ITAR, shipments to Iran, North Korea, Sudan, Syria, Venezuela, and Cuba, and other sanctioned entities. Rough diamonds, regardless of value, is really important. If you're going to export rough diamonds, we need a license. What are the priorities for exports? We're working on to make it everything automatic, so that way we can have more cooperation with other agencies. Apply risk management utilizing advanced information to effectively target for violation and facility legitimate exports. Conduct outreach with the export community, like we're doing right now, to increase information sharing, improve the quality of the export information provided to CBP, and streamline the export process. DIS is being implemented for the export environment to capture documents such as licenses. We already have that in place. Again, we're going even further than that. We're exploring how to reduce the need for you guys to come to our office to send the paperwork, so that way we can actually make our decision faster. So once we get it through, through the email, which we'll be setting up soon, maybe this fiscal year after January, we're looking into it right now as we speak. So that way it would improve our system. So that way, you guys would get a determination faster than you're currently getting. All right, so who are the key regulatory agencies? Department of States, we don't know that, 22 CFR Part 12130. The licensing by Directorate of Defense Trade Control, DDTC. International Traffic in Arms Regulation, ITAR. The United States Munition List. Now we have the Department of Commerce, based on 15 CFR Part 73774, which is the licensing by Bureau of Industries and Security, BIS, Commerce Control List, which is a big thing that we're looking into now. Department of the Treasury, 35 CFR Part 200, and licensing by Office of Foreign Assets Control, OFAC. That's more targeted to Venezuela, Cuba, in our AORs, maybe Iran as well. Country-specific sanctions and regulations, especially designated nationals and block persons. We get a lot of those as well. We had the U.S. Census Bureau, 15 CFR Part 30, law that governs the general reporting of the EEI and the CED. Office of Foreign Assets Control, OFAC. So that's the U.S. Department of Treasury. Like I say, Cuba, Venezuela, Iran, North Korea. Those are the main countries that we actually look into when it comes to OFAC. If you have anything going that way, feel free to give us a call. That way we will actually address your questions. We prefer that you give us a call and inform yourself before you send anything that you actually make a mistake, I should say. Because that way it will help us and helps you have everything done the proper way. Enforce. What is the Office of Foreign Assets Control? Well, they enforce economic, trade sanctions, and embargoes primarily against countries and groups of individuals such as terrorists, narcotic traffickers, and threat to national security. The countries right now is Cuba, Venezuela, Iran, North Korea, Sudan, Syria, Russia industry sanctions, Chinese military industrial complex, Crimea region of Ukraine. List a specifically designated national and block persons, foreign financial institution list. This is a list that it comes out, it keeps getting updated. So what I always tell everybody that calls me, do not save that list. Go to the link. If you don't have it, do a Google search, OFAC list of special designated nationals. That way you know, because it keeps changing every day, every week, every month. Don't just think, I saved it last year, it should be current. Don't make that mistake, okay? And like I always tell my officers, Google is your best friend. All right, Department of Commerce. We're talking about weapons now. As you can see on my slide, you got regular handguns, you have machine guns, you have tasers, you have weapons parts. All that is regulated by the Department of Commerce. Export Administration Regulation, EAR. We're talking about weapons, chemicals, believe it or not, anything related to vest, bulletproof vest. Make sure you have the proper license. Technology, that's another big thing that people don't think about. Technology, even things that have to do with agriculture. We're looking into all those things. All right, the Commerce Control List. There's 10 categories. You got 0, nuclear material, facility and equipment, and miscellaneous. Number 1, materials. chemicals, microorganisms, and toxins. Number two, material processings. Number three, electronics design, development, and production. Number four, computers. Number five, telecommunications and information security. Number six, sensors and lasers. Number seven, navigation and avionics. Number eight, marine. Number nine, propulsion systems, a space vehicle, and related equipment. Department of State International Traffic in Arms Regulation, ITAR, 22 CFRs Part 120 to 130, controls the export and import of defense articles and defense services governed by the United States Munition List, USML, Part 121. How to determine if a license is needed, really important. What is being exported? Where is it being exported to? Who will receive the items? Some individuals and organizations are prohibited to receive those items. You know, the end user is really important. That 7-Eleven is really important that you complete so that way we know who is going to get it, or that way we can actually make a determination. What would the item be used for? Proliferation of weapons of mass destruction, munitions, nuclear, biological, chemical, or missiles. It's really important. Do you know what is it being intended to? Because some things have dual purposes. Like some material for nuclear could be used for, fuel for a power plant, but on the same token can be used for just create weapons of mass destruction and the dual use commodities. Okay, it's really important that you keep that in the back of in the back of your brain, so that way you're like, okay, let me look at it. Should I look at it? Help us out so that way everything goes smooth. Detention and seizures is actually the process that we go by. When we detain something, if the officers believe the commodity requires a license that is not provided, the officer may send a detention notice, which is CBP Form 6051D, to the exporter, freight forwarder, or carrier to hold the shipment. Commodity specifications are then referred to the appropriate licensing agency through the Exodus Command Center to determine if a license is required. It's really important that once we issue that 6051D, you make sure that commodity does not leave the United States. Why? Because then if it goes, we have to issue what is called a return notice, so that way you could send it back. And then if you're not able to send it back, we will penalize you. And sometimes the penalties are a little bit high because it's based on the value of the commodity. So you don't want to be in that situation. And unfortunately, we can actually talk about things later on. If that happens, we look into your record. We can try to mitigate a little bit of the penalties, but that's out of our hands. That's not us. So be careful with that. Seizures. If a license or license exemption is required but not present, CBP will determine the appropriate enforcement action. This may involve seizures of the cargo. If the shipment is seized, it is then turned over to the local FP&F office for processing. They would inform the exporter of their legal options. Release. If no violation is involved, then the shipment will be released to be exported. Now, when we talk about FP&F, we get emails every day from them asking what do we think about it should be done. How can once the process goes through, they take on the consideration how many times you have been a violator. Have you come to us to talk to us? Have we conducted outreaches? So every time you come to our office or you request an outreach, we'll be more than happy to talk to you. We will put it on the log so that way we know that you were informed about what's going on. We will look if right now I see that one of the companies has more than 2 or 3 mistakes, we will call them and say, listen, come in, let's talk about this, so that way we avoid this mistake again. Because most of the time it's lack of training. We know that every company has a big turnover in personnel, and sometimes you guys don't have time to provide the training. We'll be more than happy to help you. Even I will be able to send officers to talk to your people and try to educate your employees as well. That's something that we're looking into as part of our outreach process. We already did a couple companies, so if you need that, feel free to reach out to us. We'll be more than happy to do so. So what are the common reasons for detention seizure penalties? Well, fraudulent declaration of cargo value as under 2,500 to avoid the AES filing. Late AES filing or missing information filed in AES. When you don't describe the commodity the proper way, wrong motor transportation submitted, EEI submitted for the wrong port of export, false claim for exemption or shipment does not qualify for the exemption. Really important that you understand that we will look at all those, and if we found anything, we will actually detain, we will seize, or we will issue penalties. And if EEI includes a license not appropriate for the shipment, we will look at the license. We will look at, okay, you have a license for this, but you shipping this. So right away, we will seize it. Okay, so make sure that if you have any questions, again, we're more than available for you guys. All right, so best practice. There's something that we strive for you guys to do. And again, we're available for you guys to give us a call. My team is more than happy to actually answer the calls. I have 2 officers dedicated from 8 o'clock in the morning to 2000, which is 8 o'clock at night, dedicated just to answer phone calls. Ensure AES and export documentation match. Export license, commercial invoice, bill of lading, packing list, shipper letter of instruction, and certificate of origin. Do not load any cargo without the ITM, the AES Post Department statements, or the AES exemption statement. Do not accept vehicles export without proper CBP validation stamp. Do not release cargo selected by CBP for examination until release. Submit complete outward cargo declaration and electronic export information to CBP. Basically, if you follow this 5 steps, I can see, I foresee you guys not having any issues with us, no penalties or not, maybe seizures. Yeah, that's something that you can't control sometimes, but the penalties, you can't control it. Miami International Airport Export Control. Right here, you have our office number, 305-869-2640. The general CBP cargo phone number is 305-869-2750. Our general email for export control is miaexport@cbp.dhs.gov. And our physical address is a Cargo Clearance Center, 6601 Northwest 25th Street, in Miami, Florida, 33122. We are in the 2nd floor, but you can just come to the main window. You ask for myself, Supervisor Rodriguez, or my partner, which is Supervisor Alvarez. He's not here today, unfortunately, but we'll be more than happy to come downstairs. We'll bring you to our office. We sit down, we talk, and any questions that might arise, we will try to give you an answer right away, and we'll work with you guys at all times. Okay, so if you have questions related to, in general, www.cbp.gov/trade is a great tool to answer your questions. Believe me, I go there a lot. Sometimes, we don't tend to know everything. I don't want to know everything. I rather look for answers. That way I know I'm 100% right. If not, when you think you know everything, you're going to make mistakes. So the cbp.gov website provides steps for AES participation and frequently asked questions. And again, if there is a question that you have that you don't find the answer, feel free to call us. Now, I would like to ask something before we move on to the questions. Basically, this is the way we operate in Miami. Keep in mind, every port might have different ways to do things. I keep hearing that, in this port, they do it like this, in this port, they do it like that. Unfortunately, every port has its own port policies in CBP based on the geographical area and the cargo that we see going out more frequently. So keep that in mind. There are some ports that work differently. Okay, so anything that I might tell you is gonna be more towards CBP, Miami, MIA procedures. Okay. Perfect. Any questions? Please feel free to let me know right now. We got 30 minutes of question.
Sure. Thank you, Officer Rodriguez. We appreciate that information very much. I will help you with the questions by reading them, and then you can answer. Once again, participants, please type your questions into the Q&A box. We will take as many questions as the time remains permits. There's a question as to why, I think you just answered this, but why would there be differences from port to port?
Well, most of the times, CBP gives the port director the leeway to make decisions based on the commodities, the passengers, and things that come to the area. Plus, you cannot compare small port to Miami port. That actually, let's say for flowers, maybe when you import flowers, let's talk about exportations. When we do exportations, if we notice, like in vehicles, that we have a lot of high-end vehicles coming through Miami International Airport, we actually require the package to be sent to us physically. Some ports don't require that because the vehicles that they have, like at the seaport and Fort Lauderdale, they're vehicles that have no value compared to the value that we have. We have vehicles that are 3 point something million dollars. So we have to be right when we allow a vehicle like that to go out because we might be liable for it. So we want to see every information available, and we actually physically go and look at the vehicle. But when you have vehicles that are used vehicles, like it happens a lot, a lot in the seaport environment, it's a little bit different. I don't know if that makes sense to you guys.
I think it does. You handle sort of sometimes different cargo, which builds up your
Exactly. Our
expenses
cargo,
in
when it
your
comes in the plane, is more high-end cargo compared to the cargo that is going to be on the container and on the sea, at sea.
Great. And along those lines, there's another question about can anyone from any state call the Miami CBP office for help?
Say it again. I'm sorry.
Can anyone from any state call the Miami CBP office for help, or would it be the port?
We prefer if the cargo is going through Miami that you give us a call. However, I have no problem answering questions from anywhere within the United States, even abroad. We've done it before. But keep in mind, sometimes we want to refer ourselves just to national policy. If you're not in Miami International Airport, or if your shipment is not going through Miami International Airport, I'm not going to get into the what if and the other port because I do not know the policy, the SOP, the standard operation procedures at that port. I know the ones at Miami International Airport. So we're going to probably more or less talk to you about national policy.
Got you. Thank you very much. There is a question. I don't know if you can answer it now or if you want us to forward
What is
it to you
DIS?
for further. It's documents that need to be filed for a vessel carrying and bringing cargo to sanctioned countries like Cuba.
Let me, Mr. Fernando, let me get back to you on that because I want to give you an 100% answer. And since that keeps changing all the time, I don't want to tell you one thing that is not correct. That is something that it keeps evolving every day. We find out there's something different that it is needed. So let me, if you please, Ms. Forbes, send me an email with that, and then we can put it in the somewhere so they know exactly what documents are needed.
Of course. Okay. There's another question that says, sometimes I receive a booking informing me that my freight is leaving out of Fort Lauderdale. However, when I check the website the next day, I see that my freight flew out of MCO. What should I do in that case?
First of all, I mean, I will talk to the airline that you're using because, that's something a little complicated that sounds like doesn't have anything to do with CBP per se. That happens to us a lot. We are looking at a cargo that supposedly is coming to Miami, and then the next day we found out that, it landed in New York. So sometimes we do get that as well. I would be more like talk to your airline to see, hey, why is this changing? That's something that happens a lot.
There was a question about exporting technology such as cell phones or computers. What would be the correct process?
Well, that's a little more complicated. It all depends on the country that you're taking it. I would say the most important thing is, first of all, look at what country you're going to send it to, so that way you can determine if you need a license or not. Because some countries you're not allowed to send cell phones or computers based on OFAC. I will give you an example: Venezuela and Cuba, you're not allowed to send cell phones and computers. Unless it's going to be used for some type of nonprofit organizations. The end user is really important, Miss Lady. Um, so try to get all the information and send BIS the information, so that way they can, give you the license. The best bet for me, I always tell everybody, take that time and get the license. That way you cover by the license. You have somebody in BIS made the determination. We see that you have a license, and that would expedite the whole process.
Okay, there is a question in the chat about free trade agreements. If you handle those, I mean, for the documentation part of it, how to handle free trade agreements.
Can you elaborate more on the question? Because trade agreements, there's a lot of trade agreements. I'm
Um,
sorry, I don't want to give an information that is not correct.
Sure, and that's a good way to remind participants to please type your questions in complete sentences so that we understand it. I That's what was written there, so I'm not sure what the question is aiming at specifically, which free trade agreement. So let me go back to the Q&A. I was just trying to pick up the questions in the chat as well. There is another question about new auto parts exports to Cuba and Venezuela.
Okay,
That
so
that
we
would
are
be
actually. I'm sorry. Go ahead, Miss Lisa.
no,
I'm
no.
sorry.
I was wondering if that was your agency or another agency, but I'll pose the
Well, we're
question to you
actually
anyway.
working on that right now, because we have several seizures that several detentions that we just happened to detain in the past, I would say, month. We're looking into it. We're working with our chief counsel, our lawyers, to see the legality of the whole thing. It's something really complicated, believe it or not, because you cannot regulate where the parts are going to, as opposed to a whole vehicle. A whole vehicle is easier to regulate than just parts. So how do we know that it's not going to the national police, or it's going to somebody that is going to be hurting the population, or in this case, somebody that is in the list of persons that we're not allowed to have commerce with. So we're looking into that right now, and I'm sorry I don't have enough information when it comes to that. We actually looking into it. Something that we just came across, and we're looking into. I don't know who asked the question. I'm sorry. What's the name of the person?
It's Jose Rodriguez.
Mr. Rodriguez, I know you're from Miami. That's probably something that happened. Yes, we're looking into it. If you're here in Miami, I think I saw that you say Miami earlier. Come to the office. We can sit down and we can talk about it. Once I have an answer, I will reach out to you. Once we establish that communication, the line of communication, and once I have an answer, I will be able to give you more information. I really, right now, we are working to find the answers when it comes to that.
Okay. There was a question about the OFAC sanctioned country list. We will have OFAC later on today, so we'll get to that question later on today. I know you mentioned it during your presentation
Yes,
about looking for that list.
I saw the question. Okay.
Okay, it looks like those are all the questions that I have here. There's another question that it is sort of a question that you might want the person to contact you as well offline, and it regards exporting goods with an ITAR license to a company located in Peru whose headquarters is in Venezuela. And would they require a special permit, or would they simply not be able to export this kind of goods?
Mr. Campos, that's a really good question. Now, the problem is that that company that company a Venezuelan company that has a headquarters. I mean, for what I see, it's a Venezuelan company has a headquarters in Peru. I'm sorry, that is located in Peru and is shipping things to Peru. How do we know that's not a just a front so to get the parts to Venezuela? So that's something that is really we have to look at everything. We have to look what type of spare parts are we talking about. Um, and again, the determination is not made by us; it will be made by BIS. They will say yes, you can let it go. No, you cannot let it go because they are the expert when it comes to that. But again, if I were you, I would look into that a little more. Always require or ask for a 7-Eleven so that way you know exactly who the end user is going to be. That's really important. And that will give, and then on the same token, that will give us a lot of information as well.
Okay, and we do have our speaker from the BIS right after this, so he might be able to expand a little bit more on that. But any other questions, please put them into the Q&A box. We still have a few minutes. Any question at all for U.S. Customs and Border Protection? Now's your opportunity. You are speaking to the expert, so please type your questions into the Q&A box.
There was a question real quick about DIS, and somebody answered already, but let me just say it in case they didn't see it. DIS is a system where you can download all the documents that is going to be presented to us. If you don't have, you should have access to it. If you don't have access to it, reach out to your local CBP area, and they will explain to you how to get the access.
Wonderful. Does the completed 7-Eleven form need to be provided with the shipment?
All depends on the commodity. To tell you the truth, sometimes, or where is it going, or if we have some type of doubt, we're gonna require a 7-Eleven. If I were you guys, I would always require a 7-Eleven. I would try to get as much information as I can from those people. Where is it going? So that way, that 7-Eleven is, like, it will help you and help us at the same time.
Okay. That's all the questions I see here. There was a question, but I'm not. It wasn't completed, so I'm not sure what
The
specifically.
one from Maledo Cabrera about different ports.
Yes, correct. Ms. Cabrera, if you want to explain a little bit more the question that you're asking regarding the different ports for departure. Okay. All right, Officer Rodriguez, I will give you back a little bit of your time. I don't see any questions here, but your information is on the screen right now. For anyone else who has a question for Officer Rodriguez, please use the information on screen to contact them. We do want to thank you for your time today. Go ahead.
Sorry, let me put our email real quick so everybody knows. That will go directly to me and my staff and my partner as well. miaexport@cbp.dhs.gov. Please feel free to reach out to us. I love when people reach out to us because that means that hopefully that will be one less thing I have to worry about later on. believe me, we hate to do the seizures because so much paperwork involved, and I have to read every single one of them. Okay, so yes, we do not like going out there and doing and seize things. I'm telling you, we don't. We enjoy when things go through. We don't have to worry about it. Everything and the public and you guys are safe, and we actually help to expedite commerce. Now, it's been a pleasure talking to you guys. I hope to do it next year again with my other partners. Thank you for your time. It's been amazing. I love the questions. I can see a lot of questions that make a lot of sense, and I now that will help me in the future and my team, so that way we know what we need to talk about when we go to different outreaches and what we have to concentrate more when it comes to training for you guys. Okay. Again, you're more than welcome to reach out to us, and if you need help with training your staff or any questions, let us know. We'll be more than happy to go for half a day, couple hours, talk to your staff, let them know, hey, this is the most common mistakes. This is what we look into. Let's work like this. Okay. Any questions, please let us know. Ms. Forrest, thank you for your time. Thank you for the invitation and thank you for having us.
Great. Thank you very much. We appreciate your time, and I agree. We would rather help you at the stage where we don't have to correct mistakes that have already been made. It's much easier sometimes to help you before you get into problems. So let us know. Thank you very much. We will now move to our next speaker from the Bureau of Industry and Security. We have with us today Mr. James Salandro. By the way, the bio for all our speakers is on our website. It's online. You can read a little bit more about them and their agency and their position within the agency on our website. But we are so glad to have James Salandro, Export Counselor from the Bureau of Industry and Security, with us today. And James, please, you may begin your presentation. Thank you.
Thank you. So I'm with my name's James Salandro. I'm with the Outreach and Educational Services Division, the Bureau of Industry and Security. And we're just going to go through an overview of BIS here. So just a brief introduction to the Bureau of Industry and Security, determining your export control requirements, identifying when you need the license, and part of that AAS reporting requirement includes providing information about what your company's exporting, where the export's destined, who are the parties to that export transaction, and how will the item be used. And in order to determine if an export control requirement exists, exporters are going to need to answer those questions. But before I go over how to answer the questions, we'll talk about some of the reasons an item could be controlled based on what it is, where it's going, who it's going to, and what they're going to use it for. Also, the activities of U.S. persons could trigger a licensing requirement and require an authorization from the Bureau of Industry and Security. And I want to also go over some guidelines and methods for the proper AES reporting toward the end of the presentation and discuss additional resources. So the definitions are in Part 772 of the Export Administration Regulations. And when you're looking at our regs, the words that appear in the EAR text in full quotation marks are defined in 772. The words that appear in single quotation marks are identified in this section, that particular section of the regulations. So if we're looking here at this slide, we'll talk a little more about the Commerce Control List, which contains the export control classification numbers. So those items in our regulations include commodities, software, and technology. So you think about, everybody understands what a gun is, so firearms. Think of a semi-automatic .45 pistol. That would be an end item, but you could have the technology plans to produce that item would be blueprints, directions on how to manufacture. If there were any software, proprietary software involved with the manufacturing of that item, that would also be controlled. The technology for creating an end item is also licensable. And we have a definition of release. The release of the technology would be considered licensable transaction could be, and you can see that definition in 734.15 of our regs. Also, the U.S. munitions list. This is the DDTC's regulations. ITAR. They have jurisdiction over the most military items, say fully automatic rifles and firearms, silence suppressors, and a lot of night vision gear would fall under their regulations, and there'd be their jurisdiction. So you would need a license from them to export those items. Our mission is right here. It's on our website as well. The Bureau's mission is to protect the security of the United States, which includes national security, economic security, cybersecurity, and homeland security. We do also have an Office of Export Enforcement, and the EE agents will investigate exports to determine if they're made in compliance with the regulations. Non-compliance can result in administrative penalties and or criminal prosecution. But what we're trying to do here today is more aimed at building informed compliance among exporters. So hopefully you would never have to have a meeting with EE. So what is the scope of the EAR? An item will be subject to the ITAR or another agency or to the EAR. Those are the scope of various jurisdictions that could encompass an item. And no item is going to be subject to two different agencies. An item is subject to the EAR if within the scope defined in the EAR in Part 734. Some things are explicitly defined in 734 as not subject to the EAR. We'll go over that shortly. Just quickly, under the ITAR, there's a provision where they could license some items that are under our jurisdiction. For example, if a police department in the United Kingdom wanted to buy a box full of fully automatic M4s, they're probably also going to want some magazines as well, extra magazines. The magazines typically would be under our jurisdiction if someone was just sending those, but the fully automatic rifle would be under the ITAR. But they wouldn't have to come in for two separate licenses, one from BIS and one from DDTC. They could ship those items that are subject to our regulations in the same shipment in one go. But if the police department, for example, wanted to purchase additional magazines, they could come to us. The party in the United States would come to us for a license in that case. So this is a little more in depth from what the previous slide showed you. What is subject to the EAR? It's important to remember that the items subject to the EAR are on the Commerce Control List, and they have a particular export control classification number. And we'll go into that in detail. What an ECCN looks like, what it means, what its relationship to the Commerce Country Chart is. Or they could be those items that are not specifically listed on the CCL, but are under our jurisdiction, would be EAR 99 items. A table, a desk, a chair, a pen, those would be examples of EAR 99 items. Most medical devices are going to be EAR 99 items. They would be subject to our jurisdiction, but wouldn't have a specific entry. For most destinations, those EAR 99 items would not require an export license from us. For some destinations, embargoed countries, they would. Even you're sending pallets of frozen chicken to Cuba, he would come in for a license. You would report it to us, and if the agency doesn't object for the AGR notification, then you'd be able to ship those to Cuba as an example of an EAR 99 item that would require a license. Certain activities of U.S. persons. So more of our controls are focusing now on the end user controls, which you could find in Part 744 of our regulations. So the activity of a U.S. person, wherever located, including any, like it says there, any juridical person organized under the laws of the United States or any jurisdiction within the United States, our foreign branches. You can see the definition of U.S. person in our regulations. If you go there, it could be somebody in the United States, citizen, permanent resident, a company, headquartered in the United States. Like it says there, the United States or foreign branches of a company, and those activities could be subject to licensing requirements. So this goes into a little. I know the slide's pretty busy. Um, a little bit into what items are not subject to the EAR. Most published information won't be subject. It says there, printed books, films, and newspapers, sheet music. If you're going to fire up your piano, calendars. So those wouldn't be considered EAR 99 items because they're not subject to begin with. The EAR 99 items are subject to the regulations. So they just simply wouldn't be, that designation wouldn't be applicable, the designation of EAR 99. Certain foreign produced items abroad may or may not be subject to the EAR, but foreign produced items in the United States are subject to the EAR. If it's produced here, it would be subject to the EAR. If the item is in the U.S., we don't really care where it was made or where its components were made. You might have heard about de minimis calculation rules, but those are for only for overseas. If you have an item that's export control, leaves the United States, is integrated into another end item, you'll be getting into de minimis calculations if that's going for say re-export. You want to there's a calculation guide in our regs that will help you make that calculation, is to see how much U.S. content is now in that particular end item, and whether or not you'd have a licensing requirement for the end item going off to another destination. I don't want to get too deep in the weeds there. If anybody has questions later, I'll be available on that. Here again, subject to the EAR, the U.S. origin items wherever they're located. And re-exports of U.S. origin items could be subject to the EAR in the form that they were received. Once again, the de minimis rules could make a non-U.S. item subject to the EAR based on the amount of U.S. origin content. And also, you might have certain transactions that are subject to the foreign direct product rules for re-export or export from abroad. The encryption software, even if published, some of the encryption items can be fairly complicated. We have an encryption helpline. We can get you in direct touch with those folks. If you have an item, if you've got questions about how to classify your encryption software, or whether or not you're going to have a specific licensing requirement based on your transaction, you can call us here at the counseling division, 202-482-4811, and we can get you in touch with the encryption folks. So how do you determine whether or not you're going to have a licensing requirement based on your transaction? So you're looking here, what are you exporting? Let's say I've got a firearm. All right, where's the firearm going? It's going to Canada. Who's going to receive it there? Cabela's, let's say. What's the end use? Hunting. And also, what activity am I supporting? Are you sure it's for hunting? Is it going to fall into the hands of a terrorist organization, and you know that? So knowledge is also a definition in our regulations. What does it mean to know something? And that's in part 772. I just want to take a minute and find that definition for you. So knowledge of a circumstance. The term may be a variant such as know, reason to know, or reason to believe. Includes not only positive knowledge that the circumstance exists or is substantially certain to occur, but also an awareness of a high probability of its existence or future occurrence. Such awareness is inferred from evidence of the conscious disregard of facts known to a person, and is also inferred from a person's willful avoidance of facts. So you can find, like I said, all of those definitions in part 772. There of our regs that you can get to through our website at www.bis.gov. Look for the regulations drop-down menu and proceed from there. This is a fantastic slide. this is how do I determine whether or not my transaction is going to be subject to the EAR and whether or not I'm going to have a licensing requirement. We want to look here right at the top. Start here. It's fairly self-explanatory. Is my item subject to the EAR? I want to go to the right first. Let's say the item itself is not subject to the EAR, but is your activity a restricted activity? And you can find those end-use controls in Part 744 of our regulations. If it looks like your activity is going to require prior authorization from BIS, you would apply for the license. If not, exit the EAR, you don't have the licensing requirement. Let's say I do have an item that's subject to the EAR. Is it classified under an ECCN on the CCL? So let's say it's not an EAR 99 item. Let's say it's ammunition. It's just a 0A505 item, so it has an actual entry in the Commerce Control chart list, rather. We'll flow down there on the left. Do any of the following apply? Is there an X in the box? We'll talk about the Commerce Country chart and what X in the box means. Do any end-use restrictions of Part 744 apply? The who and the what restrictions is my firearm going to an entity that's listed on one of the lists of restricted parties, which you could find in the consolidated screening list. I'll show you where to find that later. You can get to that link through our homepage. Is there an embargo or sanction that's part of 746, where you can find the sanctions information in Part 746? Do those apply? If you're answering no, then the export, re-export, or transfer in country. A transfer in country could also require authorization from BIS. You would be no license required there. But let's say you have the EAR. I spoke about this briefly before. An EAR 99 item there in the center. We're looking at the arrow that's going right. Do end-use restrictions of Part 744 apply, or does an embargo or sanction of Part 746 apply? Yes. So that means you would have the licensing requirement. Well, now that you know you have the requirement, are you eligible for any of the following? A license exception, are you shipping to somebody on the validated end user list, or could you possibly use a temporary general license for your particular transaction? So this looks more complicated than it is. But this chart in this form in Part 732 is not there. It doesn't include the is your activity a restricted U.S. person activity. So this is a newer chart. Maybe you would definitely want to save this one. I'm not sure when it would be published in the regs in this form. The old chart is there without the activity box. What do I have? So the Commerce Control list is not a dual use list. Folks, you might hear that a lot. No item necessarily needs a military application to be subject to the EAR and on the CCL. Military items, non-military items, strictly commercial items, items with a dual use, those are all could be under our jurisdiction. The items on the CCL are described according to the technical parameters. So if you're looking to classify your items, somebody familiar with the terminology of those technical parameters, engineer, a scientist, the designer, is really in the best position to assess whether or not the item will be classified on the CCL. If you're looking to see if your item has an entry. So this illustrates the order of review for the Commerce Control list. You don't want to simply do a word search for what you hope is a relevant word for your classification. You really need to systematically focus in on the correct category and product group on the CCL, and then look through the ECCNs there on the list according to their hierarchy in this order of review. There's more than one correct category. If you think that your item might fall under, it could be as category 0 item, or it could be a category 1 item. You need to repeat the process and then potentially think about coming in for a commodity classification request if you can't successfully categorize the item yourself. You really need to get it right, because otherwise you won't know whether or not, based on what you have and where it's going, you're going to have a licensing requirement to begin with. So that's critical. And this is a continuation of the order of review. Let's take a look at what exactly is an ECCN number, break it down, and what do the particular components actually mean. You can see here it's a 5-character alphanumeric designator here, the 9A610. That first character is a digit, and that is going to be the category designation. You can see the categories on the left there, 0 through 9. This looks like an aerospace and propulsion item. The second character will be a letter. That's one of the 5 product groups. So the A means this is an end item. If it were an E item, let's say it was a 9E610 item, that would be the technology required to, for example, produce this end item. And I would say, for the most part, the technology will be more highly controlled. If you think of it in this way, if you think of it, well, I've got one end item I'm sending, so the end user has only one of those items. If I send them the technology, then they can theoretically produce an infinite number of those items. Those last 2 digits of the specific entry number will generally correspond to the Wassenaar arrangement list for the national security controlled items. The Series 600 ECCNs indicate items that were previously controlled on the ITAR, for which the EAR controls are more stringent usually. So when you're looking at trying to identify what kind of item you have, you really want to start by looking at the category. First, if you're looking at category 0, it includes miscellaneous facilities, equipment, nuclear materials. Then it lists facilities, equipment, and miscellaneous items. So when I'm directing folks to say they want to send firearms outside the country, and they're looking at their licensing requirements there, I direct them to category 0, and they stop reading with nuclear materials. Firearms are in category 0. If you keep on reading, you'll see that miscellaneous. I can understand why it's a little confusing. When you're filing your AES filing, you want to be sure you don't miskey the ECCN number. AES is programmed to validate existing ECCNs. If not, you'll most likely get a fatal error. Okay. So this briefly will show you the reasons for control in the ECCN number. I want to find in the regs here where you can actually look more into what these mean. These are the Commerce Control List, the base controls. You look at Part 742 of our regulations. You can read about what some of these reasons for control, where they come from, what they mean. Okay, so this is a screenshot from the newer website, and we do have several handy decision tools that will help you classify your item. If you go to the home page and you go to the Learn and Support drop-down menu and you click on About Learn and Support, you can see the link to the decision tools there on the left. And this page will pop up and take you to the decision tools. If you're looking at whether or not, if your item is specially designed, what licensing requirements you might have, this is a good place to start. You can always give us a call too at the counseling division. We can help you walk through how to classify your item. This slide's a little repetitious, just reiterating the composition of ECCN entries, what they mean. And once you found the ECCN, you want to look at the description of the item they control in the heading. Some ECCNs have dozens of subparagraphs and subparagraphs, so it's important to classify your item down to the applicable subparagraph level. And we should have an example of an ECCN here. So we're looking at a 9A 991 aircraft. And the NES means not elsewhere. It's specified. And gas turbine engines not controlled by 9A001 or 9A101. I'm glad they chose this as an example for how to read an ECCN, because this ECCN refers back to different ECCNs, which you'll also need to read to see if your item was controlled under a 9A001 ECCN. If it's not, it would most likely fall under the 9A 991. And here you look at the licensing requirements for what the item is. It looks like it's controlled for anti-terrorism purposes, and it has a UN control. Where you would find the licensing requirements for an item that's UN controlled in 746. So you would have to refer to that section of the regulations. You won't see that on the Commerce Country Chart. And below, there are the list-based license exceptions. Let's say you had a licensing requirement for this item to a particular destination. You might have a license exception available to you. There are several list-based license exceptions. You'll see whether or not those are available in the actual ECCN number. But other license exceptions could apply. If you look at Part 740 of our regulations, there are additional license exceptions with their descriptions, the restrictions on license exceptions as well in 740.2. So anytime you're looking at potentially using a license exception, you want to look at 740.2 first to see if any of those restrictions to all license exceptions apply. Here are the codes used in the ECCN that point to the country chart. The country chart's in 738 of the regs. We'll get to that shortly. The X's and boxes. Dual use, I just want to repeat, it's not a reason for control under the EAR. The reasons for control under the EAR these are the reasons for control under the EAR for licensing purposes, and they're found in the control section of each ECCN, which we just saw. These 2-letter codes here. So let's say you're trying to find your ECCN. How exactly do I do that? You could ask the manufacturer if you have something like a laptop or an iPad, for example, that you want to send abroad. A lot of times those companies will have, Apple, for example, have a chart on their website. You can see what it's classified under. That's helpful. That's not every manufacturer. Sometimes if they have it, they won't give it to you. You could try to self-classify. We went through part of that process working with an engineer or a scientist, someone who knows the item's technical characteristics. Or if you can't do that, if you can't determine it on your own, you can submit for the formal request through SNAP-R. That's our online application system for processing the commodity classification requests and license applications. Our licenses are free. The classification requests are also free. They could take a couple of weeks, though, for a commodity classification request to come through. Licenses, I would say the median processing time is 39 to 45 days. You want to keep that in mind if you're looking at applying for the export license. if you decide to apply for a commodity classification request, you'll need to set up a SnapR account, which you can do right on our website. It usually takes 3 to 5 days to set up the account. But once you go into the application, it's one form, so you won't need to be filling out each field. It's one form for both the commodity classification requests and the license applications. And I would just focus on filling out the fields that are required. They'll have an asterisk there. And there are helpful videos on our website that will show you exactly how to apply for a commodity classification request and for a license application, and also exactly how to apply to set up the SnapR account. If you go to the homepage, the www.bis.gov site, and you look at the Learn and Support tab, the second item will be the training videos. Click on that, and the first row of videos are the videos on SnapR. If you're looking at the categories, a particular category, let's say category 0, if you look down at the very end of category 0 in the regulations, each category will have this designation. Items subject to the EAR that are not elsewhere specified in the CCL category or in any other category in the CCL are designated by the number EAR 99. So that's where it is in our regs. They're not explicitly listed on the Commerce Control List, as we spoke about earlier. There are certain, when you're looking at the filing requirements for the EEI, all exports of items on the Commerce Control List to China, Russia, or Venezuela, regardless of the value, unless the export is made under certain exemptions listed in paragraph C4 of 758. 758 of our regs will show you all of the AES filing, the EEI filing requirements there. If you have any specific questions, I would direct you to the part 758. If you were looking to see when you need to make the filing, when you need to include the ECCN number, that's all right there in our regulations. So this goes over a little about what we spoke about before. Now, let's say we have an EAR 99 item. There's sometimes confusion that it never needs a license. We know that isn't correct. EAR 99 is commonly reported for NLR exports, but some of those EAR 99 items can be licensed depending on where it's going, who it's going to, and how it's going to be used. So it's important to remember that EAR 99 doesn't mean no license required. That's the basic point of this slide here. Okay. So where is your item going? You've answered the first question. What is it? So we know what our item is. So now we move on to where's that item going? For the sanctioned destinations, the Commerce Country Chart in Part 738 doesn't indicate the license requirements or indicate all of the license requirements. As what the country chart will refer you to 746 if you're looking at embargoes and special controls. For example, if you're looking at the Commerce Country Chart and you see you have an item going to Syria that's an EAR 99 item, you won't see X's in the box for that destination country. It'll refer you back to another part of our regulations. So you've got to look at that to see if you have any licensing requirements in 746. So there's reasons for control that we spoke about earlier, applying a country by country basis. So that's really the what and the where. determining whether or not you're going to need a license to apply for the license based on what you have and where that item's going. And you need to compare the reason for control and the country of destination in the Commerce Country Chart, which we'll look at an example of next. I know this is a lot of information if you haven't seen this before. So here's the Commerce Country Chart in Part 738. Now, if you remember when we were looking at the ECCN for the 9A item, there was a reason for control of AT and UN. For looking here, it looks like they're using Argentina as an example. And let's say we have an item going there, and there's a firearm, an FC control. If you look at a column FC and it says 1, there's an X in the box for Argentina. If we went back to that ECCN entry, the item that we were sending, and it had an FC control, it would apply here for Argentina. You would then look at that reason for control, look at the Commerce Country Chart, and see if there's an X in the box for the destination. So then right off the bat, if you had an FC1 item going to Argentina, you would have to apply for the export license if a license exception wasn't available to you, right? So that's the way to think about license exceptions. You want to think, well, first of all, do I have the licensing requirement? I've determined that I have the requirement. Is an exception available to me? I wouldn't start right off the bat looking for a license exception until you determine whether or not you have a requirement. You may not have a requirement. So if you don't have a requirement for a license, then you wouldn't want to be looking at license exceptions, because there's nothing to be accepted from. And so let's say that we were looking at that 9A item before. It was controlled for AT. The AT columns are there, right, all the way to the right, and almost no country has an X in the box there on this page of the Commerce Country Chart. So if we were sending that 9A item to Argentina just based on what it is, but since there's no X in the box, it wouldn't require a license based on what it is. Then you'd have to determine the end user and use controls. Do I have a requirement based on the who and what they're going to use it for? This goes into more detail about the what nations have comprehensive embargoes, the sanctioned destinations, what countries are subject to the UN arms embargo, and these are all in 746 of the regulations. Here's the complete list of Part 746 sanctions dealing with Russia and Belarus. You want to go ahead and take a look at 746.8. So when a destination is in EAR Part 746, the country chart won't show license requirements for the destination. So you need to really read through Part 746 embargoes and other special controls first for those license requirements for an embargoed or sanctioned destination. So you've got to do a little more legwork there. For additional country-specific restrictions, you can go to our website to find the links to the FAQs that are there under, you can see country guidance. There's FAQs there for Cuba, Russia, other destinations. The Cuba guidance is especially helpful. There's a lot of folks there sending items to Cuba, and I will direct them to the guidance there. Now, I mentioned this earlier. The contemporary export controls focus on the end use and end user. They're more targeted, sort of unlike the Cold War era controls that mostly focused on the destination country. More of our controls are focusing on the end user, end use. Part 744, we went through that at the beginning. So this is the who. Who will receive your item? You can screen the parties through the consolidated screening list, see if who you're sending the item to, based on that, whether you're going to have a licensing requirement. If you go to our homepage, and right on the homepage, if you look in the center toward the right, it says quick links. The consolidated screening list is the second item from the bottom, and it will take you straight to the CSL search page. You can also download these lists if you're at the CSL search page. You can search by. You can search all of the lists. That's what I recommend. Under where it says sources, so it searches the list from all the different agencies. You can see if the party is there that you're sending the item to, and determine whether or not you can have a licensing requirement based on that. You can download them into spreadsheets if you want to. The lists are always being updated, so it's important to screen the party before you engage in the transaction, just to cover your bases. I would recommend searching the name and the address if you have of the entity, and also just searching the address. So that could raise a red flag if the name of the party doesn't pop up, but you're sending an item to the same address as a listed entity or several listed entities. Then I recommend getting in touch with us. Just give us a call here at the 202-482-4811 number. We can put you in contact with the end user review committee. I think that's helpful. If you see a listed entity there, they also have a helpline, but that could raise a red flag. You can read about examples of the red flags in Part 732 of the regulations, and Supplement 3. Here's some advice here. If there are red flags, like I said, inquire, give us a call. We can put you in touch with the right folks, try to get you the answer. Self-blind, this is part of knowledge. Reevaluate the transaction. Do you really want to be doing business with a listed entity or a party who won't disclose the end use of the item? This goes a little more into knowledge, and I know that I read the definition to you there earlier. Know equals the reason to know, reason to believe. It's a very, very comprehensive definition of knowledge in our regulations. This goes a little more into detail of what are possible red flags. These are here. They're in Part 732, just to help you kind of think through a transaction. Product capabilities do not fit the buyer's business. Why is a toy manufacturer buying ammunition? Right, it's kind of a no-brainer. They're evasive about the destination or end use. Right, they're not going to tell you what the item is going to be used for, or if there are end users, they won't reveal them to you. Other end users. And we spoke before about the end user controls. Yep. Okay. Okay. Can people hear me?
Hi, we're just doing a quick sound check. If you can hear James, can you give a thumbs up?
Does it look like folks are able to hear? Okay, great.
Oh, yep. Okay, thank you. Please continue.
Okay, thanks. So think I skipped a slide. Okay, there are other agencies that have U.S. licensing authority. OFAC, the Department of the Treasury, has comprehensive sanctions on Crimea and the covered regions of Ukraine. There, you could be in a circumstance where you would need a license from OFAC as well. And there, you can search their lists on the consolidated screening list as well. There's some of their information is here on this slide. Now, there are 3 types of transactions that can be reported in AES that are subject to the EAR. These licensed exports, license exceptions, and no license required. Now, license application parties to the transaction, only a person in the U.S. may apply for the export license under the EAR. You've got to be here. If it's a re-export, obviously, that means you're abroad. Every application is going to require the applicant who's shipping the item and the ultimate consignee who is going to receive it in the foreign destination. Those must be on the applications. You could have additional end users. You could have an intermediate consignee. You could have several intermediate consignees on the license application, but you have to have those 2. Someone has to send it. Someone's got to receive it. The purchaser, sometimes this trips people up. Only if the purchaser is located abroad. If they're in the U.S., you don't need to list them on the license application. That actually, the system will actually allow the U.S. address in there for the purchaser. All parties that participate in the transaction are subject to the EAR and must comply with the EAR. Take a look at 758 responsibilities of the parties to the transaction. Acting, this is important here at the bottom, acting through a forwarding or other agent or delegating authority does not relieve anyone of responsibility for compliance. When information on the license is in the EI filing system, the D number is the license number. That's a unique identifier for the export re-export license. The majority of our licenses will start with a D. You'll have the validation approval date on there, the date from which an exporter is eligible to file the license transaction. It could take a few days to get into the system there. The initial license value, decremented license value. So you can have multiple shipments on an export license, and the license could expire one of several ways. Either the expiration, you've reached the expiration date, so the date that the license is valid for. They're usually good for 4 years. I know firearms now is a year, something like that. So it's depending on what you're sending and where you're sending it. The quantity. Once you meet your quantity, then the license is no longer valid, or the price, whatever happens first. Some common troubles here, where you'll get an error. The value report, the value of the item being exported should always be a lesser value than the shipment value. Each time in license decrementation, each time an exporter uses a license, the total value of the license will be reduced by the license good value reported in the filing system. So if you try to send something that exceeds the license value, exceeds the shipment value, AES will deliver a fatal error. Reporting a license value in excess of the total initial value of the license received from commerce, it's just common errors that folks get when they're trying to do the filing here. We spoke earlier about license exceptions. If you determine you do have that licensing requirement, one of many license exceptions could be available to you. You could potentially you could have multiple license exceptions available to your transaction. You really have to read through 740, 740.2, the restrictions, and then the specific license exception you're looking at using to see if any of the restrictions in the license exception would apply to you, and whether or not you just have to come in and get the license. It's we spoke when we were looking at the ECCN number, that 9A item. I showed you the list-based license exceptions. Those will appear in the ECCN entry, but those are not the only license exceptions that could potentially be available to you. Those list-based exceptions, you'll know if they're available to you because they're listed in the ECCN entry. If they're not there, they won't be available to you. Sometimes you'll see STA listed in the ECCN entry where there are restrictions on using STA. So you'll know based on what the item is and the ECCN entry whether or not you could use STA. So you'll see the restrictions in there. These are just some examples of what restrictions could potentially apply to a license exception. If it's denial orders, if it's a denied party, if there's support of prohibited activities, these are sort of no-brainers. Knowledge that a violation has or is about to occur, you won't be able to use that license exception. Now, if you're looking at a Series 600 item, you really want to look at 740.2 carefully for what license exceptions could potentially be available to you. So we went through this before, the list-based exceptions, the transaction-based exceptions, certain country groups. If you see GBS listed there, Group B, what we call Group B countries, you can find the list of those in 740, potentially have those license exceptions to you based on your transaction. I know I had a lot of slides. I was a little worried about getting through all of those. I'm just trying to do a little bit of triage here and see if I can. Let's go and see. Okay, so export clearance requirements when you're making the AES filing. You know, what am I looking for? When do I report the ECCN? This is probably more of interest to this crowd here. You really want to go take a look at 758. Okay, right. Don't make false statements. That's pretty obvious. So here is when to include the ECCN on the AES record. Just want to go through this briefly. All licensed exports. So if you've got regardless of the value, if you've got an item that has it's licensed, you've got a license number, you've got to put the ECCN on the AES record. All license exception exports, with the exception of TMP, there's a specific circumstance there where temporary, where you don't need to put the ECCN on there. No license required exports unless it's controlled for anti-terrorism reasons or is EAR 99. No EEI filing required if it's under, if it's going to be under the value threshold. Exports of .z items that meet or exceed the performance parameters of ECCN 3A090 or 4A090. So you'd have to go in there and look at those ECCN numbers and determine whether or not that you have an item that meets or exceeds those performance parameters. I wanted to point that one out. That's a little new. It's integrated circuits and the semiconductor rules there. Destination control statement. This is everybody's favorite statement. On the commercial invoice, right? The exporter must incorporate that information as an integral part of the commercial invoice whenever items on the commerce control list are shipped. Exported in tangible form, obviously. Unless you're making it under the license exception BAG or GFT gift, or the item's designated as EAR 99. Where should it be included? And I'm getting close to the end here. Just bear with me for a few more minutes. It's important to remember that the AES record is a legal document, so false statements may be a violation of the EAR. We went through this before. All parties to a transaction are subject to the EAR, are responsible for compliance with the EAR. Obviously, the information on your export control documents have to be consistent with any license that's issued. But if you have questions, you can always give us a call. And excellent, the encryption helpline is here. So you can see that there at the bottom, the 202-482-0707 number. We have two offices, one in DC and one in California. And that, remember our email address. You can email us questions too. We'll call you back. That's the ecdoexs@bis.doc.gov email. If you sign up for a SnapR account and you need a password reset, or you're having trouble with SnapR, you can email us too. We can try to get you help expeditiously. Export enforcement's also there. Keep that one handy. And so the rest of the slides here, I just had additional resources. I know I wanted to try to get through some of the handout material that I provided earlier on some of the new. Let's see, the license exception entries. You should have those. It's from the AES-TIR appendix there. If you should have 4 pages on the notified of advanced computing, the advanced computing authorized license exception, and the NED. Also, the implemented. I really wanted to draw your attention to that license code C70, implemented export control, because those, what the destinations and what items by ECCN number are available for that IEC license exception are integrated. They're incorporated by reference into our regulations, and they can be found on our website. And that's about it, folks. If you have any questions, give us a call. I'll be on the phones this afternoon. Then I'll jump back on if anybody has additional questions about the EAR and BIS. I'll pop back on for question time.
Okay, wonderful. Thank you so much, James, for that very comprehensive information about BIS and export licensing. We do have some questions in the Q&A. You can perhaps jump back on and get to those. We will get to whatever questions you don't get to later on in the Q&A session as well. But I just wanted to let you know that there were a few questions that came in during your presentation. So
okay, I'll take a look at those in the chat, and then I'll be back on later on for the question time.
Thank you so much. We appreciate your participation today.
Yep.
Okay, so that moves us to the break. We have until 2 from she's a senior compliance specialist in the Office of the Directorate of Defense Trade Controls. I know you've been hearing DDTC and ITAR a lot this morning from the other agencies. So now we will learn about their role in the export process. And as usual, we have a list of acronyms that our South Florida District Export Council co-chair, Jim Anzalone, has put into the files tab for you, so you can follow along with those acronyms. And also, you can type your questions into the Q&A box. We will get to as many of them as time permits. And we do have a couple ITAR related questions already, Becky, so I'm just making you aware of that there in the Q&A. So without further ado, over to you.
Awesome. Thanks so much. So I am Becky Hint. If I say Marks, it's because that's late breaking news. So if you've worked with me before, you probably did under Becky Marks. And I am a senior compliance officer in the Office of Defense Trade Controls Compliance. And it's good to know that my government colleagues have already done my job for me, and you are all now ITAR experts. So that's awesome. There's 2 primary channels through which arms are transferred around the world. So there are commercial sales, what we call direct commercial sales. And Both ITAR and EAR items are sold via the direct commercial sales process. And there are government-to-government sales. So that's your FMS programs, your foreign military financing, and your security assistance. All of this falls under the conventional arms transfer policy, as I'm sure you've heard this morning. Different government entities are responsible for different parts of these different trade channels. So, as a foreign policy tool, the U.S. government views the sale, export, and retransfer of defense articles and defense services as an integral part of safeguarding U.S. national security and furthering our foreign policy objectives. One of the most popular questions we get asked is why we are not part of the Department of Defense. And to give you a little history lesson, back when the Arms Export Control Act was written, it was identified that the sale of defense articles should be classified as a foreign policy tool rather than a wartime, activity. So that is why we are part of the State Department, but we do work very, very closely with our Defense Department colleagues. Defense export controls are designed to help meet the legitimate defense needs of our allied countries, foster regional stability, balance defense and human rights considerations, and prevent proliferation of weapons and technologies. Our regulations of exports, retransfers, re-exports, and retransfers of defense articles and defense services are designed to protect the national security and foreign policy interests and foster peace and security of the broader international community. So there's a number, like I said, different agencies that are responsible for this. The Department of Homeland Security, obviously, and the Border Patrol within that department. The Department of Commerce oversees dual use technologies, and I think we just had a BIS speaker just a minute ago. Financial sanctions through OFAC and the Department of Treasury. The Department of Energy manages nuclear proliferation issues. DITSA is our subject matter expert within the Department of Defense, and they manage the Technology Security and Program Administration. And then my office within the Department of State controls the export of U.S.-made munitions. So we fall within the Bureau of Political Military Affairs. So working actually our way up through the org chart here. So our Deputy Assistant Secretary is Mike Vaccaro. If you've been around for a while, you might have worked with him either when he was at DCSA or BIS. He falls under Stan Brown, who is currently our Acting Assistant Secretary for Political Military Affairs. Stan works under Ambassador Bonnie Jenkins. Ambassador Jenkins we call it the T family here at the State Department. She's the Undersecretary for Arms Control and International Security, and she reports directly to Secretary Blinken. The role of the PM Bureau in defense trade is to advise the Secretary and drive global security policy, integrate diplomacy and defense, and build security cooperation. Annually, we oversee over $170 billion in sensitive technology exports. Within PM, we manage both FMS and direct commercial sales. So this is speaking for the whole Bureau. We offer nearly $7 billion a year in security assistance and $9 billion in Title X security assistance. And our primary role is to implement the White House policy priorities to promote the President's Conventional Arms Transfer Policy, the CAT policy. A lot of people, you hear that thrown around. But that's just the President's overall policy toward what weapons we sell where, basically. DDTC specifically is responsible for commercial exports of defense articles and defense services. So that term I used earlier, direct commercial sales, that is what my office manages. We're charged with controlling the export and temporary import of defense articles and services described on the United States munitions list in accordance with the Arms Export Control Act and the ITAR. So I'll get into it in a couple slides. The Arms Export Control Act is the legislation, and the implementing regulations are the ITAR. We seek to facilitate legitimate defense trade with our partners and allies while denying adversaries access to our technology. We ensure that regulations keep pace with innovation, that U.S. industry and foreign partners comply with applicable policies and requirements, and that the munitions export process is reliable and predictable. We work with absolute integrity and transparency and diversity and accessibility at all levels. That is kind of our mission statement. Not kind of, it is our mission statement. Another org chart for you that I'm just going to go through really quickly. So under Das Vaccaro, we have 4 main offices. He also has a senior advisor in Shelley Atkinson. But our Office of Policy is headed by Director Sarah Heidema. Our licensing office is directed by Catherine Hamilton. Compliance is currently, we have John Foster in as acting director, while Jay Shin is on a detail. And then our management office is directed by Dr. Allison Smith. So this is a really good eye chart to break down for you. And I know that we did, just have a BIS speaker, so I won't go too deeply into this unless there are questions. But it kind of breaks down the 2 different control regimes and our jurisdictions, our control lists, and again, working our way up, the implementing regulations, and then the overall arching legal authority. So again, the Arms Export Control Act created the ITAR, which contains the United States munitions list, which gives the State Department jurisdiction over defense articles, tech data, and defense services. And when you're considering the jurisdiction of an item, you're going to take the hardware piece it relates to, and figure out if that's a munition, and then all the defense services and tech data they follow the underlying article. We have 21 categories. So I always tell, when I'm trying to explain to my aunt what I do for a living, we control everything from large firearms all the way up through the F-35 program to spacecraft, directed energy weapons, all the really cool things that our defense industrial base are working on. Information can also be exported, and we call this intangibles. So again, when we talk about what falls on the ITAR, it's the item itself, the widget itself, but then all of the tech data, the recipe to make it, software related to it, all of those, that know-how is also controlled. And it's kind of that concept of teach a man to fish, right? We don't want to be teaching our adversaries to fish. So thus the controls on the tech data and the software and that know-how. So it's not limited to hardware. You can also do what's called defense service. And that would be if I go over and literally teach a foreign person how to build something, design something, use something that's on the U.S. munitions list. Physical transfer is not required. I can export technology to a foreign person by a simple conversation. If I sit here and describe to you how to build a defense article, that is an export of technical data. I can export technical data via email, and I can do it all on U.S. soil. So if I'm talking to a foreign person in the United States and I, give them an oral presentation, that is considered an export of a defense article in that technical data. Breaking down our office responsibilities, I'll start with licensing. That's probably the one that people are most familiar with, obviously, because that's who the public interacts with the most, because that is who you go to for permission to do things. So our licensing office responds to a request from the U.S. defense industry and some foreign parties. It determines if proposed exports are consistent with our foreign policy and national security objectives. They do solicit input from our interagency partners, and I'll kind of go through the staffing process in a minute. And then they make a final determination on license requests. So whether to approve with provisos, RWA, which means return without action, or deny. Our licensing office also does a huge amount of outreach to our U.S. defense industry and foreign partners. We find that it's a lot easier to follow the rules when you understand them well. So our licensing office takes the lead on teaching industry how to properly obtain authorization prior to export. ITAR authorization requirements are a lot different than BIS. We are not so country-based with some few exceptions. I'm sure you've heard AUKUS flying around. So we already had a Canadian exemption. We have now exemptions being created for Australia and UK as part of the overarching AUKUS treaty. But other than that, our controls are not country-based. So no matter what, you generally require an authorization for the transfer of a defense article. Subject to the USML control, regardless of its destination or whether it's being used to perform a defense service. Several exemptions do exist, which would make it so no license is required. Things like by or for use of USG. We have exemptions, again, for some certain countries. And then we have exemptions related to certain approved end uses. Transfers that would require authorization from us, though, are permanent exports of defense articles, temporary exports of defense articles, re-exports or retransfers of defense articles. So that means we've exported from the United States and that it's being re-exported to either another country or retransferred to a different destination within the original end-use country. Temporary imports of defense articles into the United States, furnishing and defense services, technical assistance agreements, manufacturer license agreements, which would be for the manufacturer of U.S. origin defense articles overseas, and warehouse and distribution agreements, which if you have questions about, I will bore you with, but they are few and far between. But basically, you build a bunch of stuff, leave it overseas, and then export it from there. Interestingly, permanent exports of defense articles are actually overseen by the DOJ and ATF. So the life cycle of an export authorization starts with our licensing office. The applicant comes in, they give us all their license documentation. We review, the licensing office reviews it. They then consult with our policy office to do a watch list review and use monitoring. So the policy review of the license is generally more focused on the foreign parties to the license. And then my office in compliance also does a watch list review to look for debarred parties and law enforcement interests, so more focused on the U.S. parties. The license then goes for interagency review. A number of our sister offices here in the Department of State, like the desk bureaus, RSAT, human rights, whatever offices that might be germane to the proposed transaction, will review it. We will also always go to the DOD for DITSA review, and DOD will then decide if other DOD entities need to review. So, for example, if it's an F-35 related license, more than likely it's going to go to the Joint Program Office, and sometimes other agencies, and DITSA handles that part of it. So sometimes the subject matter expert for the specific technology involved might be DOE, might be NASA, might be MTech. So part of DITSA's role is determining what other subject matter experts outside of the State Department should be reviewing the license. Based on dollar thresholds, mainly, congressional notification may be required. And depending on the technology involved, missile technology assurances through MTech may be required. Finally, licensing has the authority to make the final determination. We do sometimes receive contradictory advice from different reviewers, and it is licensing's job to reconcile the input and to make a final determination whether any provisos need to be on the license, make a final review, and do their quality control processes. Again, just to kind of give you the overall goal of the staffing process, going back to the Arms Export Control Act, the Arms Export Control Act seeks to promote the foreign policy concerns and protect the national security of the United States. So the foreign policy arm of that is going to be our Department of State level reviews. So our regional bureaus, our watch list reviews that I talked about, our human rights policy reviews. And then the Department of Defense side of the review process, the technical review by DITSA, and then going out to the services is going to be the national security portion of that review process. Licensing, again, does the final review and issuance of the license, and we already talked about the 4 possible outcomes: approve with provisos, return without action, or deny. By and large, approve with provisos tends to be the most common outcome. You'll see our authorizations adjudicated by calendar year, and you're going to see that steep drop off, right? And that is directly because of export control reform. To quote my friend Kevin Wolf, we were looking to put higher fences around fewer objects. And so Department of State licensing did drop significantly, but the licenses that we now focus on are of our most critical technologies. Moving on to the Office of Compliance, so where I work, our core responsibilities are to adjudicate registrations for arms manufacturers, exporters, and brokers. There's a requirement in the ITAR that you must be registered with DDTC to manufacture defense articles within the United States if you're a U.S. manufacturer, or to export defense articles from the United States if you're a U.S. exporter. We also register brokers regardless of nationality. If you broker U.S. origin defense articles, you must be registered with our office and come in for a prior authorization prior to doing those brokering transactions. That used to be a footnote. Frankly, since, the war in Ukraine, that is a much bigger footnote. So we do try to highlight the brokering part because it's not very well understood by industry. We ensure ITAR compliance through various means, including company visits and outreach, voluntary and directed disclosures, criminal referrals, administrative or civil penalties when warranted. So that's the team I work on, the compliance and civil enforcement team. And we are responsible for both reviewing violations reported to our office, coordinating with law enforcement on specific cases, and also enforcing the ITAR generally through the consent agreement process, which I'll talk about in a minute. We do have a law enforcement liaison division that directly coordinates with law enforcement on criminal matters, including trial support. And we mitigate foreign acquisitions of U.S. defense companies through the CFIUS process, the Committee on Foreign Investment in the United States. Our newest division is actually called Transaction Analysis and Mitigation, our TAM division, and they review those foreign investments. Voluntary and directed disclosures are our primary mechanism for engaging in enforcement. You'll see when I go through the numbers, we don't do 668 enforcement actions a year, but we do receive, roughly 700. It was a little bit lower in 2023, but roughly 700 voluntary disclosures a year. So we grant great mitigating credit to companies who come in and tell us when they violate the ITAR, because that allows us to try to mitigate the national security and foreign policy concerns that might be associated with that violation. So we do have great input from U.S. industry, coming in and telling on themselves, and they will see that generally does not result in enforcement. You'll see the breakdown of how many enforcement actions we actually do a year. But if they think they have violated any provision of the AECA, any regulation, order, license, or other authorization, they can come in with a voluntary disclosure. However, if we receive derogatory information about an entity, either through a tip from our law enforcement partners, or maybe sometimes, we'll get tips from competitors, or through the licensing process, if someone comes in with a really wonky license request, we might issue what's called a directed disclosure. So that is when we, in the form of a letter, request information regarding a potential or actual violation based on information received from other sources. And this is just the breakdown of voluntary versus directed disclosures. Again, you'll see we don't do very many directed disclosures. Our goal is not to go on fishing expeditions, but rather to substantiate credible information reported to our office. Our most common violations that we see when we're talking about the U.S. parties to a transaction: unauthorized export of defense articles, including tech data. Again, tech data is actually the more common violation because there's a lot more of it flying around. It can be in very non-traditional formats, such as an email. And it's actually, in terms of level of concern, sometimes much higher because it is the how-to of building these crown jewel technologies. A lot of times, incorrect export control jurisdiction results in unauthorized exports. Again, that's where I was saying that it's when you're looking at how your article is controlled and whether you need to be following, either the ITAR or EAR, you need to have that classification correct and know what set of rules you're playing with, right? And so it's really, really important to properly classify your items prior to export. Proviso violations can be common, especially in more complicated licenses and agreements. Unauthorized furnishing of defense services, misuse of ITAR exemptions. Again, exemptions that at their nature is that you don't come to us first. So if you misuse an exemption, you do have to come in and tell us about it. A lot of administrative violations, especially with some of the larger companies, just due to volume of transactions. And then we see a lot of failure to properly implement and manage licenses and agreements, register, or submit your 5 or 60-day notices to our office. From foreign parties, unauthorized re-exports and retransfers, obviously somewhat common. A lot of times they have incorrect or unknown export control jurisdiction, which results in those unauthorized re-exports and retransfers. A lot of times they don't know to go back to their OEMs and ask if something's ITAR. And their US-based OEMs sometimes just assume everyone knows the ITAR. So that happens somewhat often. Unauthorized access to defense articles, especially in foreign ports, freight handling facilities, and warehouses. This has gotten a lot more common since our change in policy on the status of Hong Kong. I think it goes without saying that there's a lot of shipping through Hong Kong, and now that is considered China per policy, we do see a lot of disclosures about transshipments, especially through Hong Kong. Inadequate physical security causes a lot of violations. And U.S. person employees of foreign companies providing defense services. So if I, as a U.S. person, find a great job in Canada building a defense article, and I really would love to go work for that company, I can, but I need to come in for authorization to do so because I am a U.S. person. Therefore, my brilliant know-how into building whatever defense article I'm building is ITAR controlled. And so if I go up there and do that work, I would be providing a defense service. So I need to seek authorization for that. It's a very simple process, but a lot of people don't know that they need to do that. All right. Sorry, I think I'm getting stuck here. The slide's not progressing. There we go. Okay. And now I think it went too far. Yes. So defense trade control policy, core responsibilities. Moving on to our next office. So policy is the lead for maintaining, interpreting, and updating the ITAR and the USML. They do coordinate very closely with DITSA as the subject matter experts on the technology on the USML, but ultimately policy is responsible for that. Our policy office also leads the Blue Lantern end use monitoring program for direct commercial sales. And they do, as I said earlier, review DCS license applications for parties of concern. Their mission is to maintain a modern and agile export control system for munitions while providing responsive, forward-thinking, and insightful policy advice and support on direct commercial sales of defense articles and services to representatives of the Department of State, U.S. interagency, foreign partners, and the exporting public. So what happens if you don't know if something is ITAR? You can submit something called a commodity jurisdiction request, and this does go to our policy office. Only the United States Department of State has the legal authority to determine whether an item is described on the United States munitions list, including foreign defense articles. The majority of OEMs do self-classify when warranted. It is essential. We would be flooded. But generally, companies, if it's very clearly described on the ITAR, they do not come to us and ask us if it's on the ITAR. However, some things are not as straightforward. So we do have a CJ procedure outlined in ITAR section 12012 that can be used when doubt exists as to whether an article or service is covered by the USML. You do not have to be registered to submit a CJ because oftentimes a company, if what they're manufacturing, if they don't know whether it's ITAR, they don't know if they need to be registered. So oftentimes the CJ is the first step to becoming registered as a manufacturer and exporter. You can submit these electronically via DEX, which is our main online portal for submissions, both of licenses and of the CJ requests. Ideally, it should be the original equipment manufacturer who submits these, mainly because they know the specs better than anyone else, and we're going to have a lot of very, very technical questions that they need to be able to answer. So that's why we prefer that the OEM submit CJs. Required information will likely come from different functional areas within your company, so including your engineering or R&D unit, business units, or legal or regulatory compliance units. When I work with companies on their compliance program, the most successful ones pair generally an engineer with a export specialist, and they work together in teams to do their commodity jurisdictions and self-classifications. Policy also handles other issues, again, such as end-use monitoring. They do the majority of the advisory opinions submitted to DDTC. We do have a process through which, if you don't understand a specific subset of the regulations, you can ask us for regulatory guidance, and that process is outlined in ITAR Section 120.22, again, filed through the DEX system. Policy is also responsible for updating the ITAR. So they routinely review USML categories. You may, if you're a big nerd like me, have seen that we're putting out some targeted revisions specific towards spacecraft right now. So we're excited about that. We also engage with our partners and allies via our policy office to make ITAR changes. So notably the AUKUS exemption that we just wrote into the ITAR, that is our mechanism for executing the foreign policy objectives of the AUKUS treaty. So there's a number of resources here. I'm sure you've seen some of these, but if you ever need to look up restricted parties or our regulatory agencies, it's just a list of links that might be helpful to you. And finally, some reference materials. Some very useful email addresses on here as well. If you need any help from our office, we're always happy, to coordinate with either the exporting public or the interagency. And I flew through that. So with that, I don't know if we're doing questions.
Yes, we are. Thank you so much, Becky. We appreciate that presentation. Very informative. We do have a couple of questions in the Q&A, and as a reminder, please type your questions for Becky into the Q&A. We will take as many of them as time permits. There was a question earlier as to how to become ITAR compliant. I was wondering if you could expand a little bit more on that. That's the question. I don't know if it's specifically as far as licensing, or maybe you recommend something like putting an export compliance program in place. But if you have recommendations on how to be ITAR compliant in a general sense, maybe we could put that as an answer. Thank you.
Yeah, absolutely. So we actually recently published, and frankly, we're really proud of this because it took a lot of work from our office, a compliance program guidelines for industry with an annex specific toward higher education facilities, universities. That gives a lot of really great guidance on ITAR compliance. The challenge with ITAR compliance that I see most often is that there's no one size fits all solution. If you're a small mom and pop manufacturer, working out of your garage, just doing, small parts and components, or even just doing tech data, your compliance needs are going to be a lot different than Northrop Grumman or Raytheon. So you want to have a right size program that still, meets all of the thresholds that will help you not export without authorization. The number one tip is to know what you have. So know how the technology and hardware that you're working with is classified, and then make sure you're following the correct set of regulations, whether it's the EAR or the ITAR. But we have, again, a really, really great set of guidelines available on our website that I highly recommend everyone check out. There's also, and I can't, for obvious reasons, I can't plug any specific events or companies, but there are some wonderful industry groups that do trainings. There are excellent consultants out there. It's, especially depending on the size of your company, it might not make sense for you to hire tons of people, but you might want to seek a consultant or outside counsel. And there's some really great export practitioners available to you. And you can research those on your own. I can't really give any plugs. And then it's always better to come to us if you're not sure about something. So that's why we have the AO process and the CJ process. Ask the questions up front and don't try to guess the answer. If you need help, it's available. We have the response team. We have FAQs on our website. If you're still confused, we have the AO and CJ process. So it's much better in the ITAR world to ask permission than forgiveness would be my advice.
Agreed. Okay, we have a two-part question. How long is a CJ going through the approval process these days, and how long should a company expect to wait on a license as well?
The CJ process especially varies greatly based on the hardware, so I really can't give you a statutory timeline on that. Licenses, and don't quote me directly, licenses are much faster. I believe our current aim is under, I want to say 30 days, but I'm not particularly confident. But if you look on our website, I believe we actually have license processing timelines available there. One note about CJs is if you do submit a CJ and you are truly unsure whether it's ITAR or not, you are allowed to treat the item as ITAR while the CJ is pending, and that is what we highly recommend you do, because obviously there was enough doubt existing for you to submit the CJ. So while the CJ is pending, you can obtain ITAR authorizations to export it. And you will not be held liable if it comes back EAR. We will not punish you for that.
Okay, thank you. There is a question here. I'm just going to read it as it is posed. And you can see if you can answer it here, or if you'd like to answer it offline. Can I export goods, spare parts, with an ITAR license to a company located in Peru whose headquarters is located in Venezuela? In that case, do I require a special permit, or I simply cannot export this type of goods to a company whose headquarters is in Venezuela?
That's a very good question. It depends is the answer, which is always the answer that frustrates everyone. Part of our license review process is going to be that review of the organizational structure of the foreign end user and the amount of ownership and control that the Venezuelan entity has over that Peruvian end user. So that is why we ask you to submit licenses and why we do end use checks. And it's really just going to depend on how those companies are structured and the level of risk associated with the likelihood of diversion to a 126.1 country, which is 126.1 is our country list of entities, countries of concern. So I would never say no, that's impossible, but I would certainly say to mitigate your risk, there's a number of restricted party screening tools that are publicly available. So do your restricted party screening up front, even before you come in for the license, and make sure you're applying for a license. And if there's an exemption available to that transaction, you may feel absolutely free to use it. Based on reading between the lines, you might not want to because you don't have the benefit of our end use monitoring review.
Okay. The next question, I think, is sort of a follow-on to the previous question. Do people need to take a certification course in order to ship ITAR-controlled items?
You do not. There is no specific course, training, credential that is given to ship or work in the ITAR space. You do need to be registered with us, obviously, to export. And as part of the registration process, you are asked if you have, ITAR policies and procedures. So that puts you on notice that you need to have enough knowledge to be compliant. And then after that, it is your liability, and you are responsible for your compliance. So I certainly don't recommend going into the defense trade if you don't have a subject matter expert available, or the ability to get some reasonable training under your belt. But no, there is no specific certification required other than being registered with our office.
Thank you very much. Are software products that use blockchain encryption subject to ITAR regulations?
Not inherently, no. I do not believe the blockchain is enumerated on the USML. So by virtue of being encrypted or being encrypted by blockchain, and it does not automatically put anything on the USML to my knowledge. I'll be honest, I'm not in the policy office, but I don't know of anything within the USML that automatically would put that on the ITAR. It's more related to the functionality of the software and whether it's related to a defense article. So the majority of software that's going to wind up being controlled on the USML is because it's directly related to a defense article described on the USML. I'll use the example I'm most familiar with, just because of some of the cases I've worked. The tactical software-defined radios. So you have a radio, but it's a military radio that can do some pretty impressive, communication things. The software associated with that radio would be ITAR controlled because it's associated with the ITAR controlled radio.
Thank you. How do I check if we are registered with your office for ITAR shipments?
Your company should certainly know there are registration fees associated. So you should have, if you're doing ITAR work, you should have something within your office called an empowered official, or your company called an empowered official. Oftentimes, especially if you're a small company, that's going to be your CEO or vice president of operations, someone at that level. But your empowered official would be someone who has significant authority within the company to have oversight over its export compliance program. And that would be the individual who would apply for registration. So generally, you have to be in a specific position of power for our office to confirm something like that. But there should be someone within your organization who knows whether or not you're ITAR registered, because you have to give us money. There are registration fees. So someone knows whether or not you paid that this year.
Absolutely. And this question follows along. It's from a different person. And it asks, when do we expect the annual registration fees to increase? Can you recap the registration costs, what they are now, and what is proposed?
So off the top of my head, I'm not a registration analyst. I do not know the numbers. I know it starts at $2,500 and goes up just based on the number of licenses you apply for. So our registration process is tiered. So the smallest tier is $2,500. And then depending on the amount of ITAR licenses you obtain, you might be tier 1, tier 2, or tier 3, depending on the size of your company and the amount of work that you do and exports that you do. That structure is not anticipated to change, but there is anticipated very soon to be a small increase in the registration fees. Honestly, more, it's going to impact the larger companies more than the small tier 1 companies. But I don't have those numbers off the top of my head, unfortunately. I believe it is available on our website. And I think we've made some announcements recently regarding either we've published it recently or is coming very, very soon about the fee increase and the timeline for that. I know it went out for public comment, so you should be able to find it on the website.
Okay, thank you very much. I was going through the questions. I don't see any others for DDTC for you. If you do have a question for Becky, please put it into the Q&A box. We will take one or two more before we have our next presenter. I'll just want to give you the opportunity to, since we have the subject matter experts here, to get your question answered.
I just explained it incredibly well, I guess.
I think so. Okay. With that, I don't see any other questions for you, Becky. I do appreciate you joining us today. Very informative presentation. Thank you for the information that you shared with us. And if any other questions come in, I will gather them and send them to you. Thank you very much once again.
Sounds great. And I'll be back online at 4 in case anything else comes up as well. So
Great. Thank you very much.
all right. Thank you.
And with that, we will now move to our final presenters for today. We have the Office of Foreign Assets and Control. I know they were referenced in earlier presentations from the Office of Foreign Assets and Control. We have Ms. Giselle Nunes as well, and she will be joined. And she,
Hi, 1, 2, 3.
Hello, 1, 2, 3.
perfect, loud and clear. Okay, so I'm now pleased to present to you Ms. Giselle Nunes and Mr. Brian Callahan, who will be going through the Office of Foreign Assets and Controls as it relates to export compliance. Over to you.
Yes, please. Hi, everyone, and thank you, Lessa. I think everyone can hear me, but if you can't, please let us know in the chat so Isabel and Lessa can monitor that. I know we were having some audio issues earlier on, but good afternoon. You guys have had quite an informative 2 days session. But as Lessa mentioned, my name is Giselle Nunes. I'm a Senior Sanctions Compliance Officer in the Compliance Division. Today I'm joined by Brian Callahan, a Sanctions Compliance Officer, also in our Compliance Division. And we, with our presentation today, we wanted to provide an overview of the Office of Foreign Assets Control, otherwise known as OFAC, and highlight some key resources and recent actions that you all may find helpful. Let me click on the next slide here. Specifically, I would say during this presentation, we plan to discuss OFAC Sanctions Toolkit to better understand the different sanction programs we administer. Also review some case studies to see some examples of OFAC's role in export compliance, show some examples of how to use OFAC sanctions lists, and even some of our common resource tools. We also plan to review OFAC licenses, so exemptions and OFAC authorizations, to highlight the differences between the exemptions and authorizations, and review OFAC civil enforcement authority and enforcement actions, which will also serve to highlight some of the general factors OFAC considers during its investigation process. I know we have quite a lot packed in the agenda, but all of this is very useful tools. At the end, we will plan to provide some key resources and try to address any questions that may not have been answered by this presentation. I know we also put together a resource document for all attendees so that it can also be helpful as some of the key links and resources that we're going to mention today. So to begin with, let's start with an OFAC overview, just to set the stage and give us a good foundation. So as many of you are aware, OFAC is tasked with administering and enforcing economic and trade sanctions against targeted foreign governments, individuals, and entities. OFAC develops these sanctions in coordination with other government agencies based on U.S. foreign policy goals and national security. So all U.S. persons must comply with OFAC sanctions regulations, and we define U.S. persons quite broadly. So this could be natural persons, which would include U.S. citizens and permanent resident aliens wherever located, legal persons, so entities organized under the laws of the United States, like foreign branches, and any person located in the United States. So in addition, our jurisdiction also extends to include any transactions within or that transit the United States, including, for example, the US dollar clearing. So let me give you an example. Entities organized under US law or any jurisdiction therein, including its foreign branches, and any entities within the US, regardless of whether organized in the US. So, for example, this would include activity by, let's say, a foreign person to the extent that they involve the U.S. and any interest in property of a block person or a geographical area subject to U.S. sanctions. So, to ensure all those U.S. persons and transactions within U.S. jurisdictions comply with OFAC sanctions, OFAC also has enforcement authority at its disposal, which we will discuss more as the presentation continues. So just want to highlight the key 3 items on OFAC's overview. So now that we better understand OFAC's mission, jurisdiction, and enforcement authority, I would say the 3 absolutes, which is what we see on this slide, come into the discussion, which is comply, report, and record. I always like to start my presentations stressing this important information because the most important guidance can be summed up into these 3 key rules, I call them. So what do we mean by comply? Well, U.S. persons and transactions subject to U.S. jurisdiction must comply with our sanctions regulations. I would say for this one, take note here that OFAC may enforce these regulations based on a strict liability standard. So who must report? So item number 2, if any U.S. person or financial institution rejects or let's say blocks a transaction due to a sanctions obligation, the person taking the action must report that action to OFAC within 10 business days of the action and annually thereafter for as long as property remains blocked. And the 3rd bullet, what do we mean by record? So all records pertaining to property or transactions that are subject to any of our sanctions, including records pertaining to any blocked property, must be kept and made available for the time period specified in the regulations. We've had a recent update to this item number 3. So previously, for example, this has been for at least 5 years, but OFAC recently issued an interim final rule to amend the regulations and extend this requirement to 10 years to align with the recent expansion of the statute of limitations for civil enforcement of certain sanctions regulations from 5 to 10 years. So the comment period for this amendment closed just recently. So the update is scheduled to become effective as of March 2025. So definitely keep an eye out for that update. So I know now that we discussed the 3 absolutes, the other key document I always like to highlight during the presentations is OFAC's Framework for Compliance Commitment, which details what OFAC considers the 5 essential components of a successful sanctions compliance program. You may have heard of this document before. I know we use it throughout all our guidance, but more importantly, I would say use it as a key resource because it highlights 5 important pillars of compliance. So these 5 essential components. So I do just want to take a moment to run quickly through each one, just to give you an idea of what they look like in terms of daily operations. So we'll start at the top of the chart. So management commitment. To highlight, management commitment basically serves as an important reminder that compliance starts at the top. So having senior management support an organization's risk-based sanctions compliance program is a critical factor to the success of the program. It is important that senior management reviews and approves the program and delegates its compliance personnel sufficient authority and autonomy to enact the policies and procedures needed to effectively implement the program. So to that end, I would say that senior management should ensure that the compliance unit receive adequate resources, which may, for example, include funding, human capital, expertise, information technology, and other resources. So we like to say it starts from the top and continues throughout the organization. So making our way towards the right, a risk assessment. So in this case, a risk assessment can help an organization focus its compliance efforts where they're most needed. So risks are potential threats or vulnerabilities that, if ignored or not handled properly, can lead to violations of OFAC sanctions. I would say one of the central tenets of OFAC's recommended approach calls for institutions to initially assess their potential exposure to OFAC sanctions by conducting a risk assessment. Ultimately, the result of the risk assessment will inform the sanctions compliance program's policies, procedures, internal controls, and training. While we always say there's no one size fits all risk assessment, the exercise should generally consist of a holistic review of the organization from top to bottom, where it assesses its touch points to the outside world. This process would allow institutions to identify potential areas in which it may directly or indirectly engage with OFAC prohibited persons, countries, or regions. So in addition, I would say to this initial risk assessment, OFAC does recommend routine or ongoing assessments because business operations, as you all know, change, and so do sanctions. So the frequency and manner of any institution's ongoing or routine assessment should be calibrated to the risk identified in its previous assessment, which is why they should be routine or ongoing, factoring in that the business operations. So internal controls is our third item here. So internal controls can take the form of a gamut of policies and procedures, not to mention technological controls. So an institution sanctions internal controls will likely include, for example, policies and procedures to identify, interdict, escalate, report, and maintain records pertaining to activity that is or may be prohibited by OFAC sanctions. A successful and effective sanctions compliance program should be capable of adjusting rapidly to updates to OFAC sanctions. So this would include, for example, new or updated regulations or the issuance of any new general licenses. Essentially, we would say that these written policies and procedures should clearly outline the sanctions compliance program and adequately address the results of the organization's sanctions risk assessment. So the key thing I would say for internal controls here is that ability to adjust, especially given updates to our sanction program. So, whether a general license is expiring or a new one is being issued, whether a new sanctions program is on the horizon, factoring all that in, especially to your key touch points in that risk assessment can help mitigate any potential sanctions violations. The next one we have here is testing and auditing. Through, I would say, an independent and objective testing or audit function within the institution is key. So either way, the institution should ensure that it is aware of how its sanctions compliance program is performing, or even more critically, possibly underperforming, and how it should then be recalibrated to address those deficiencies or updated to account for changes in an institution's risk assessment or sanctions environment. Testing would allow for that, auditing would allow for that to be able to spot check any of those deficiencies and gaps in a good sanctions compliance program. And the last category we have here is training. So training should be tailored to an institution's specific risk profile and be scoped to the products and services it offers. So an institution should train all appropriate personnel on its compliance program and internal controls on a periodic basis. The institution's risk assessment should also guide decisions like the frequency of training and who should be trained. So whether it's annual, periodically, quarterly, all of that is key for being able to ensure that you have the most updated employees that can know all the information and can better support the sanctions compliance program. Let's go to the next slide here. So on this slide, we're going to take a closer look at the risk assessment component. OFAC strongly encourages anyone subject to U.S. Jurisdictions as well as foreign entities conducting business with U.S. persons in or with the United States or using U.S. origin goods or services to implement measures that mitigate the risk of exposure to sanctions activity. So, such as providing goods or services to parties subject to U.S. sanctions, or dealing in property in which there's an ownership or other interest of sanctioned persons. So, in this type of industry, you certainly want to factor in any kind of touch point like the ones I mentioned, whether it's the goods or services or potential ownership of a counterparty or someone you are engaging with in business. In looking at the risk matrix on this slide, I would say it comes from guidance intended for financial institutions, but still has a basic concepts relevant for non-financial institutions. There is a spectrum of areas to consider, as we see here from the low, moderate, and high. So if, for example, there is a small business with well-known non-sanctioned customers based in one location and activity is limited to routine business, then they probably will not encounter sanctions-related risks all that often and will assess their activity as being on the low side of the risk matrix. However, if there is a medium or even large business that is expanding to international activity, taking on high-risk customers, exporting or importing in high-risk regions, then more than likely they will deal with a much higher risk. They will probably see more OFAC hits or concerns when screening their activity and may even require more due diligence to ensure compliance with sanctions. So OFAC does strongly encourage organizations to adopt a risk-based approach to compliance. And this is where we say there's no one size fits all. Factoring in your risk is key. And you've probably heard us say this many times before, but it does recognize the unique challenges faced by companies as they frame OFAC's strict liability legal enforcement standard policy in the context of the institution's individual capabilities and risk activities. So on this next slide, like I said, I mentioned we put together a resource document for you all, but on here and the resource link for the OFAC website, which I believe is the first one, navigates you to some of the key resources. So you're looking over on the left-hand side for those additional resources, which will take you to the OFAC information for industry groups. So here you can look at this page, the OFAC information for industry groups, for some additional guidance, which would be including the risk matrix I just mentioned, which is tailored to specific industries. If you don't see something, I would say specific to your industry or to address the direct question or concerns, let us know. You can make a recommendation for guidance you want to see through OFAC's compliance hotline. We're always eager to provide guidance where it's most helpful. So definitely please feel free to escalate those requests, feedbacks to us always. So on this slide, referencing the OFAC Compliance Commitment Framework, which also is referenced on that resource document, towards the end of the Compliance Commitment Framework, on the last few slides, we include some common breakdowns or deficiencies that lead to violations that are mentioned, like I said, in the last 4 pages of the Framework for OFAC Compliance Commitment. On this slide here, you see the list of 10 items, which is a non-exhaustive list that can help guide improvements to your own compliance programs. Specifically for this audience, I wanted to highlight 4 key items or breakdowns or deficiencies that might be helpful just to give you a big picture of some of the aspects that might affect you in this industry. So we're going to look at those highlighted in blue, a different color than the regular black font. So starting with item number 3, so that's facilitating transactions by non-U.S. persons, including through or by overseas subsidiaries or affiliates. So for this example, multiple organizations subject to U.S. jurisdictions, specifically those with foreign-based operations and subsidiaries, have engaged in transactions or activities that violated OFAC's regulations by referring business opportunities to, approving, or signing off on transactions conducted by or otherwise facilitating dealings between the organization's non-U.S. location and OFAC-sanctioned countries, regions, or person. So for this example, in many instances, the root causes of these violations stem just from a misinterpretation or misunderstanding of OFAC's regulations. So companies should definitely ensure any activities they engage in, for example, approval, seeking contracts, procurements, etc., are compliant with OFAC regulations. In item number 4, exporting or re-exporting U.S. origin goods, technologies, or services to OFAC-sanctioned persons or countries. So for this example here, we would say non-U.S. persons have repeatedly purchased U.S. origin goods with the specific intent of re-exporting, transferring, or even selling the items to a person, country, or region subject to OFAC sanctions. In several instances, this activity occurred despite warning signs that U.S. economic sanctions laws prohibited the activity, including contractual language expressly prohibiting any such dealings. These are instances like I mentioned that we identified through those enforcement actions. We'll cover those a little bit more in the later slides, but this is ultimately the key deficiencies that we're seeing factoring when it comes to exporting or re-exporting U.S. origin goods. Item number 6 is the next one on our slide here. So this is utilizing the U.S. financial system or processing payments to or through U.S. financial institutions for commercial transactions involving OFAC-sanctioned persons or countries. So for this one, many non-U.S. persons have caused violations of OFAC regulations by processing financial transactions to or through U.S. financial systems that pertain to commercial activity involving an OFAC-sanctioned country, region, or person. So although no organization subject to U.S. jurisdiction may be involved in the underlying transaction, such as the shipment of goods from a third country to an OFAC-sanctioned country, the inclusion of a U.S. financial institution in any payment associated with these transactions often results in a prohibited activity. So this goes back to the jurisdiction aspect we were speaking about. So, the parties may not be U.S. parties, but here in this case is the clear involvement of a U.S. financial institution. So, for example, the exportation or re-exportation of services from the United States to a comprehensively sanctioned country or dealings in block person in the United States, if that had the involvement of the U.S. Financial institution, you would see it as one of those key deficiencies or breakdowns in that institution's compliance program. And lastly, the one we're going to cover is item number 7. So this is improper due diligence on customer clients. So for example, this may involve ownership, business dealings, etc. So one of the fundamental components of an effective OFAC risk assessment and sanctions compliance program is conducting due diligence on an organization's customers, supply chain intermediaries, and counterparties. So various administrative actions have been taken by OFAC involved improper or incomplete due diligence by a company on its customers, such as their ownership, geographic locations, counterparties, and transaction, as well as their knowledge and awareness of the OFAC sanctions. So factoring this in is key. I would say for today, we're only covering these 4, but definitely look towards the document. Like I mentioned, it's the last 4 pages on the compliance commitment framework, just to get some additional examples on the other ones that we're unable to cover today. I will move on to the next slide where Brian will take over here to give us an overview of OFAC Sanctions Toolkit.
Hi, good afternoon, everyone. Thank you, Lessa and Isabel, for hosting. We're very excited to be here and to talk a little bit further. I'm going to start out by diving deeper into sanctions themselves. I'm sure we're all too familiar with the term sanctions, but what they are in the OFAC context and how do OFAC sanctions programs differ is something that we're going to break down in a little bit more detail. So first, let's discuss how OFAC has delegated a range of authorities, the most common of which are shown on this slide. The 5 categories listed here are kind of the art behind the science of sanctions. These categories of sanctions authorities allow OFAC to administer various types of prohibitions. So for now, let's start by breaking down these sanctions. In the first instance, in the 2 basic categories are at the top of the chart. OFAC sanctions generally take one of 2 forms. They are either blocking sanctions that block property, or they require some action that is less than blocking. You may hear OFAC refer to these less than blocking sanctions as non-blocking or tailored prohibitions. And then next, let's moving on to the bottom row there, the second row of sanctions authority types. This is where things get a little bit more complicated. When you hear OFAC talk about sectoral, secondary, or menu-based sanctions, the key thing to know is that each of these can include either blocking or tailored prohibitions, or a combination of both. So it's important to understand the authorities behind each sanctions program to know which tool is being used and what the effect is. So let's discuss the terminology. And so you know what everyone is talking about when you hear these terms used in the future. OFAC sectoral sanctions may take a variety of forms, including blocking or something less than blocking, but are always intended to target a specific sector or multiple sectors of a country's economy. OFAC does not always use this tool to prohibit all transactions involving an entire sector. Sometimes sectoral sanctions are used to signal OFAC's general intention to target persons operating in this targeted sector, or perhaps engaging in certain activities that are also occurring within that sector. For sanctions programs that employ the secondary sanctions tool, this typically involves OFAC targeting people who do business with persons who are already sanctioned by OFAC. So as an example, let's say a non-US company does business with a company in Iran designated under the Iran program, and the transaction between those two parties never involves the US financial system or any US persons. OFAC's Iran program has secondary sanctions authority. So if this transaction meets the criteria under that authority, OFAC could impose sanctions on that non-US company for doing business with the already sanctioned company. It's secondary in the sense that the sanctions derive from activity with an already sanctioned person or region. Menu-based sanctions can be defined pretty literally. Essentially, they typically take the form that OFAC has delegated authority that says, here's a list of bad things someone might do. And if we determine someone has done any of those bad things, here's a list of prohibitions we can impose. We essentially have a set menu of prohibitions or types of sanction tools that we can choose from and may impose when the specified criteria for those individual tools are met. And those menu items themselves can be any of the other types of authorities that I just discussed, from narrowly tailored prohibitions that only restrict certain types of transactions, all the way up to the authority to impose blocking sanctions on targets. Remember that these are just some of the common categories of sanctions available to OFAC. Not all sanctions programs will include all of these authorities, and some may include others. So even if you have two different programs using the same prohibitions and the same authorities, they may not be used in the same way. These sanction tools may not be the main focus of your business operations, but depending on your sanctions exposure, you certainly may need to understand how these types of sanctions work. Next slide, please. Now that we've covered OFAC's various authorities, let's look at the effect of prohibitions. So, in other words, what happens when OFAC applies those authorities to sanction a person or activity. When it comes to the forms that sanctions can take once they are implemented, the most common form you'll see OFAC use is list-based blocking sanctions, which comes from the authority to block persons. So what do I mean by blocking? When OFAC blocks an individual or entity, it means that U.S. persons or persons subject to U.S. jurisdiction are required to block any property or interest in property of that individual in the U.S. person's possession or control. For example, if that blocked person has an account at a U.S. bank or with a U.S. company, the U.S. bank or company would be required to block or freeze that account. And blocking also means you cannot engage in dealings with the blocked person, absent any specific authorization or general authorization or an applicable exemption. We call it list-based blocking because OFAC adds the names of many blocked targets to our specially designated nationals and blocked persons list to make it easier to comply with these sanctions. We'll talk more about that later. Now, a lot of these terms are defined in our regulations, like property and interest. For now, it's enough to know that both are very broad, and there are details on how to block property too. And you might have noticed I said most are listed. There are also times when blocking sanctions apply to non-listed persons, like entities owned 50% or more by those listed persons. They may not appear on our list, but they are still considered blocked by operation of law. You can learn more by reading some of our FAQs on what we call OFAC's 50% rule. You might also see OFAC employ its blocking authority more broadly, like when we block an entire government. There are also types of other sanctions lists that relate to sanctions that call for something less than blocking, which generally means U.S. persons have to reject or refuse and engage in the type of activity specified by those sanctions if it involves the listed person. You can think of those as list-based prohibitions. Finally, the most expansive type of non-blocking tailored prohibition we tend to use are broad location-specific sanctions, which typically prohibit all or certain categories of transactions with an entire region or country. So again, the effect is that you would reject or refuse to engage in the various categories of activity or all activity with persons in that region or country as applicable by the existing sanctions. So next, we're going to move on to our case studies, and we're going to take a closer look at 4 specific studies to determine or to demonstrate the application of sanctions. Our first one is found within our Russian Harmful Foreign Activities Sanctions Program, and it's going to show us a closer look of how OFAC may apply debt and equity sanctions through our sectoral sanctions authorities. Directive 3 of Executive Order 14024 of the Russian Harmful Activity Sanctions Program prohibits certain transactions with respect to the financial services sector of the Russian Federation economy. Specifically, it prohibits U.S. persons from engaging in all transactions involving new debt of specified tenors or new equity of persons determined to be subject to these sanctions. All financing in support of such new debt or new equity, and any dealing in such new debt or equity. Persons subject to these debt and equity sanctions can be found on OFAC's Sectoral Sanctions Identification List or SSI list, or persons may be subject to these sanctions based on OFAC's 50% rule that I just previously discussed. If you take a closer look at the text of the prohibition, it gets very detailed about the prohibited maximum tenors depending on when the new debt or equity was created. For example, for debt that was issued on or after March 26th of 2022, the maturity of such instrument must be 14 days or less in order for a U.S. person to engage in dealings with it. So, if the activity involves a person on OFAC's SSI list or that is owned 50% or more by someone on the SSI list, then institutions should ensure they understand the terms of the prohibition and are only processing non-prohibited transactions. Move on to the next slide. However, the debt and equity sanctions are just a small part of the several tools OFAC uses in the Ukraine, Russia-related, and the Russian Harmful Foreign Activity Sanction programs to address specific foreign policy goals and our national security priorities. As you can see in this chart, there are several prohibitions, bans on certain key imports and exports, restricted dealings with Russian financial institutions, and prohibited services, to name just a few. For additional information on this very active program, I would direct you to review the sanction authorities and any related guidance OFAC has provided that is all available on our website. So continuing on with this case study, I'm sorry, I think I clicked ahead. That was my fault, Giselle. Continuing off this case study, we can also see how OFAC's authorities interact with export controls. And for industry members, that is specific to the individuals on this call, I want to also highlight how OFAC coordinates with the respective agencies, such as the Bureau of Industry and Security, FinCEN, which is a bureau also within the Department of the Treasury, the Department of Justice, the Department of State, all on numerous fronts. Specifically for export controls, OFAC and BIS regulations can interact or overlap in certain programs. For this reason, it's important to coordinate with both agencies and review the respective licenses and authorizations that may be applicable to your very specific activity. Ensuring you are in compliance with all respective agencies is part of the business's risk assessment. Moving on to our second case study, I'm going to look at the Chinese Military Industrial Complex Companies, or our CMIC sanctions program. We have an opportunity to show you something from one of our smaller sanctions lists that we collectively often refer to as our non-SDN lists to differentiate them from our SDN list, which only lists persons who are blocked. This image is a screenshot of a search result in OFAC's sanctions list search tool that we'll also talk about in a few slides. You'll notice if you use OFAC sanctions list search tool that all the listings in the tool are divided to either SDN listings or non-SDN listings. This is an example of a listing from the non-SDN China's Military Industrial Complex Companies list. Without going into the specific prohibitions that apply to each of the OFAC's non-SDN lists, the important thing to note here is that the persons listed on these non-SDN lists are usually subject to sanction prohibitions that do not require the outright blocking of assets, but they do involve some other kind of economic limitations. This is why we refer to these as list-based prohibitions rather than list-based blocking sanctions. A short and sweet explanation of the CMIC list is that U.S. persons are prohibited from purchasing or selling publicly traded securities of any company on this list. As you know now, because this is a non-SDN list, that denotes that it is not blocking a requirement. Also, it doesn't mean that U.S. persons are prohibited from doing all business with the companies on this list. It just places limitations on U.S. persons' ability to engage in transactions related to certain financial instruments. This is an example of an entry on the list that would look like when you search for it using OFAC sanctions list search tool. You can see that this entry for Huawei Technologies identifies this company as a non-SDN by looking up at the top right corner that we have circled in red and lists the associated sanctions program tag right underneath it. So you can see there non-SDN and CMIC to reference the Chinese Military Industrial Complex sanctions program. So now we're going to move on to broad location-specific sanctions. And here's a quick comparison of just a few of the types of activities prohibited under the Iran and Syrian sanctions programs, both of which employ broad location-specific sanctions among other sanction tools. These are some direct examples from the Code of Federal Regulations. As you can see, there are some differences between these programs' prohibitions that are shown. Most notable are the broader import and export restrictions in our Iran sanctions. By comparison, our Syria program focuses on petroleum and petroleum products on the import side, while exports of services are more broadly prohibited. Again, this is why it's important to understand the different sanctions tools that OFAC employs and to understand how these tools are specifically used in each sanction program. The bottom line is that it varies, and transactions that would be rejected under our Iran program may be permissible under our Syrian program. To better understand and review OFAC sanctions program, we recommend to review the regulations for each in the Code of the Federal Regulations. Obviously, OFAC cannot take credit for this one, but Title 31, Chapter 5 is all things OFAC, and we have helpfully included links to the regulations all over our website. This is where you will find all of OFAC's codified regulations. Now, an important note is that not all OFAC sanctions are codified. Some are only online, and those can be found on our sanctions program and country information page. This page is your one-stop shop for all things pertaining to any specific sanctions program that OFAC administers.
Thank you, Brian. I think that is a good, helpful recap of the array of prohibitions that we offer throughout our different sanctions programs. Some of the resources that Brian mentioned, for example, the sanctions list search tool, that resource link is provided in the resource document we shared with you all. Brian also made mention to the Code of Federal Regulations, as well as the sanction program and country information page, 2 key links just to give you kind of the big picture of a sanctions program, especially, for example, if in your filters you're getting a flag for Syria or Iran and you're not quite sure of what you should be looking for or where you should find this information, the sanctions program and country information page can give you kind of that high-level overview just to understand the resources that are out there. So all 3 of those links are available in that reference document, so please be sure to use it, refer to it if a question when it comes to complying with OFAC sanctions ever arises. Another key question we get all the time during our outreach events is about what you can do if you want or need to engage in activities that are prohibited by sanctions. So for these next few slides, let's look at the type of licenses OFAC offers, as well as some of the common exemptions from the regulations. And I know Brian was mentioning some as well in the specific case studies. So far, I would say we've talked a lot about rules and things that U.S. persons are not allowed to do, but there are a surprising number of things that U.S. persons actually can do pursuant to OFAC sanctions regulations. These generally fall into 3 categories, the 3 categories you see listed here. So let's start off with number one, exemptions. So these are categories of activities that are excluded from our prohibitions altogether. So no licenses are required. Many, but not all, of our sanctions regulations identify exemptions for certain types of transactions. For example, activities related to information or informational materials, or transactions related to travel. Those, I would say, are two common activities exempted from many sanctions program. Common exemptions are detailed in Section 203B of the International Emergencies Economic Powers Act. To review exemptions available in each sanctions program, I would say look to Subpart B, the prohibitions in the relevant programs regulations. So when you're viewing, let's say, the Code of Federal Regulations, you'll see the breakdown for each program. Once you select on the program, you would be able to find the different subparts, and you're looking for Subpart B to kind of give you the quick recap of some of those exemptions in that specific program. Next up, we have licenses, so general licenses. So OFAC uses licenses to authorize transactions that we want to allow, but would otherwise be prohibited. So OFAC licenses can take two forms. So here you see the general licenses first, or the specific license as a second form. General licenses broadly authorize certain categories of transactions. So, for example, a general license may authorize all transactions related to medical devices or personal remittances. And no one would need to submit a license application for a general license because OFAC does issue these and make them available for public use. More importantly, I would say general licenses are what we call self-certifying. So in other words, they do not require any further authorization from OFAC to rely on them so long as the activity you're looking to do meets the criteria of the general license, so falls within the scope of the general license. You can certainly find more information about our general license on our website and in our frequently asked questions section. This is a key thing also that Brian was mentioning with those case studies, that sometimes a general license may be codified already in the regulations or available on our web page. So that's under that sanctions program and country information. So you certainly want to look at both for key resources of, what general licenses are out there that may be applicable to your scenario. The last, I would say, rounding things out at number 3 are specific licenses. So sometimes individuals or entities, let's say including companies or banks, apply to OFAC to request authorization to conduct prohibited activity that does not meet the terms of an existing exemption or general license. So in this situation, OFAC may agree to issue a specific license authorizing such activity on a case-by-case basis. These two examples can appear a little confusing sometimes, especially the difference between, I would say, a general and specific terminology. The key thing to stress here is a general license is for a general set of circumstances and generally available for U.S. persons to use without further approval from OFAC, while a specific license is a very specific authorization for a very specific circumstance and only for the person listed in the specific license. General licenses are public, but as I mentioned, specific licenses are not made public by OFAC. So also keep in mind, I would say that specific licenses all have expiration dates. Some general licenses may have expiration date, but not all of them. So we do expect that those who engage in activities, for example, that rely in either type of OFAC licenses, to keep a detailed record of this, but more importantly, to review what is authorized and allowed in the general license. So whether the specific license or the general license, understanding what the license allows is key. So in this situation, now that we covered exemptions and authorizations, I will turn it back over to Brian to continue our civil enforcement discussion.
Yes, so thank you, Giselle. And now that we have a better understanding of how sanctions work, let's look at how OFAC's civil authority works. Let's say that there is an entity that is subject to U.S. jurisdiction, and despite their best compliance efforts, they become aware that their actions may have resulted in a potential violation of U.S. sanctions. OFAC encourages anyone that may have violated OFAC's regulations to disclose it to us voluntarily. The process itself is easy. We have an email address dedicated specifically to these kinds of submissions, and it is OFAC disclosures, all one word, at treasury.gov. Moving on to some more details about civil enforcement. We'll go into all the different various enforcement outcomes that you can see on this slide, from no action letter to a cautionary letter to a finding a violation, and kind of culminating in a civil penalty. And we'll teach you how to interpret OFAC's enforcement actions so you can zero in on what OFAC intends to highlight. OFAC's economic sanctions enforcement guidelines, which are also part of our Code of Federal Regulations in Appendix A to Part 501, serve as a general framework for the enforcement of all economic sanctions programs. These guidelines spell out how OFAC will calculate a potential monetary penalty, the basic parameters for the potential outcomes listed on this slide, as well as what we call the general factors, a list of factors that we use to evaluate apparent violations. So let's take a quick look here at our beautiful chart. On the far left, you'll begin with no action. If OFAC determines that there is insufficient evidence to conclude that a violation has occurred, and or based on an analysis of the general factors concludes that the conduct does not rise to a level warranting an administrative response, then OFAC will take no action. If you submitted a disclosure to us and we decide to take no action, we will let you know by sending a formal letter with that decision. Next, cautionary letters. If OFAC determines that there is insufficient evidence to conclude that a violation has occurred, but believes that the underlying conduct could lead to a violation in other circumstances, and or that a subject person does not appear to be exercising due diligence in assuring compliance with the statutes, executive orders, and regulations that OFAC enforces, or finally that a violation has occurred, but that a more severe outcome is not warranted under the circumstances, OFAC may issue a cautionary letter, which may convey OFAC's concerns about the underlying conduct and or the subject person's OFAC compliance policies, practices, and or procedures. These two actions represent a final enforcement response to the apparent violation, unless OFAC later learns of additional related violations or other relevant facts, but does not constitute a final agency determination as to whether a violation has occurred. Next up, the third step in their escalation ladder, you'll see a finding a violation. If OFAC determines that a violation has occurred and considers it important to document the occurrence of a violation, and based on analysis of the general factors, concludes that the subject person's conduct warrants an administrative response, but that a civil monetary penalty is not the most appropriate response, OFAC may issue a finding of violation that identifies the specific violation. A finding of violation may also convey OFAC's concerns about the violation and or the subject person's OFAC compliance policies, practices, and or procedures, and or identify the need for further compliance steps to be taken. If OFAC determines that a violation has occurred and based on analysis of the general factors concludes that the subject person's conduct warrants the imposition of a monetary penalty, then OFAC may impose a civil monetary penalty. But if you review our public enforcement actions, you will note that this is not common. Rather, before it gets to this point, OFAC and offending parties often will reach a settlement. So you'll see a number of settlements on our website. Moving on, if you're interested in reading up about the details of these factors, please take a look at OFAC's Economic Sanctions Enforcement Guidelines, which I previously mentioned are Appendix A of Part 501 of the Code of Federal Regulations. And they outline the general factors as seen on the bottom of this slide that OFAC considers when determining administrative actions. Pause there for a second. Next, let's look at an enforcement case study. This is in a recent enforcement case involving trade transactions and apparent violations of the Iranian transaction and sanctions regulations. You may recall from earlier that as a comprehensively sanctioned jurisdiction, many transactions with Iran are prohibited for U.S. persons. This case highlights the risks and potential costs that non-U.S. companies are exposed to when using the U.S. financial system for transactions that may involve U.S. sanctions persons or jurisdictions. Commercial activity that might not otherwise violate OFAC regulations, such as the sale of non-U.S. goods by a non-U.S. person to entity in an OFAC-sanctioned country, can nonetheless result in a violation when the financial transactions related to that activity are processed through or involve U.S. financial institutions. Further, as this particular case demonstrates, non-U.S. companies that obfuscate the involvement of sanctioned persons or jurisdictions in shipping or payment documentation so that U.S. financial institutions process those transactions, expose themselves to significant penalties. Additionally, on March 6, 2024, the U.S. Department of the Treasury, the U.S. Department of Commerce, and the U.S. Department of Justice issued a Tri-Seal compliance note to explain and highlight the various obligations of foreign-based persons to comply with U.S. sanctions and export control laws. This compliance note specifically discusses risk that non-U.S. persons face when they engage in conduct that causes U.S. persons to violate sanctions, including obscuring or omitting references to the involvement of a sanctioned party or jurisdiction in a transaction's documentation. OFAC encourages non-U.S. persons engaged in businesses dealings that may involve OFAC sanctions persons or jurisdictions to review OFAC's guidance and take appropriate action. Accordingly, non-U.S. companies engaging in transactions involving U.S. persons are well served by implementing a risk-based sanctions compliance program. Such a compliance program should include risk assessments to identify business partners or activities that pose potential sanctions-related risks. Such a compliance program should also implement effective risk-based internal controls to identify, interdict, escalate, and prevent violations of OFAC's administered sanctions. Next, we'll see public enforcement actions that they can be found on our website under our civil penalties and enforcement information page. We often publish an enforcement release that summarizes the apparent violations and OFAC's analysis of the general factors, including OFAC determined to be aggravating factors, and why OFAC determined those to be mitigating factors. The key item I want to highlight is the compliance considerations section, found in more recent enforcement press releases. This section highlights the risk that you may face if you are engaging in similar activity and provides the key takeaways that should almost be like a learning lessons for industry members.
Thank you, Brian. And while we're on this slide, this is another key resource that we provided in the reference document about how to find OFAC enforcement actions, especially ones that have been recently issued. What Brian was able to cover today in the one example, because of our limited time, is a good example that might affect you in this industry. But more importantly, the compliance consideration section that Brian's highlighting is kind of the key lesson. So if at the end of the day you're not able to review all the facts of the case or review the details of what OFAC found to be aggravating or mitigating, I would highly encourage you to at least review the compliance consideration of any newly issued enforcement action, just to be able to see what OFAC is highlighting for industry members, what they should be on the lookout for, key lessons learned, or even some aspects that they should consider for their sanctions compliance program or any deficiencies identified. So this is definitely a great resource, and like I said, the link is in that reference document. And this actually brings us to our resource section of our presentation, that I also want to direct your attention to some other available resources that we may have mentioned, but didn't go into full details during our presentation. So here in this helpful FAQs, or frequently asked questions, I know collectively in past outreaches and in using our sanctions and search tool, if you've ever contacted us, we probably would have referred you to our frequently asked question 5, which helps to assess potential matches to purchase on persons on our sanctions list. But on our website, besides this common one, you can also find OFAC's answers to so many frequently asked questions. You wouldn't believe, I would say, how many questions are frequently asked, enough to warrant OFAC publishing guidance. I think, and Brian would know with me, we're well over 1,000 at this point of frequently asked questions. And these questions will range from specific sanction programs or specific topics. So sometimes I know we also get questions about, well, how can we find a frequently asked question that might be relevant for our situation, or, how can we best direct it? A question to see if OFAC has provided guidance. The nice thing about our online tool is that you can keyword search these questions, as well as you see on the left-hand image, or you can search by sanction programs or certain categories for relevant FAQs. You can even search by an FAQ number. So for example, I mentioned FAQ 5 and you're like, I would like to review it. You could also type in the number. So you're able to search the FAQs in a variety of ways without having to memorize all the numbers. So even if you have some common ones, always helpful to save those links as well. The next resource we have here is, and you might have been already made familiar with this if you're signed up to our recent actions, which I would highly encourage you if you are not. But in our recent actions, we launched the announcement of OFAC's modernization, but also OFAC's ability to release more guidance, but through movies. So this started in 2023. We launched 2 different series of videos on Treasury's YouTube channel to provide the public with easy to access information and instructional guidance on OFAC sanctions and OFAC resources. This would include walkthroughs of things like the sanctions list search tool. OFAC is also in the process of releasing future videos. So stay on the lookout for those updates through our recent actions and let us know what you'd like to see. We've also had people express that they're unable to access those videos or where can you find them? On the main homepage, which is like that first link that is mentioned in the reference document. On the main homepage, you're going to see the image that's on the left-hand side that says, I need help with, and it brings you straight to the OFAC videos by clicking on that video box. And then all of them are displayed. So even if you have a question about OFAC, I know, for example, Brian and I gave you the background on OFAC. If you need a refresher or you need some updates, we have that here. We have even a video soon to come out about the license application process. So I know we've also got those queries on well, how can I go about submitting a license for specific licenses, as we mentioned. So there's different instructional videos in the works. And then the last slide I have here, and I do want to leave this up for everyone, is OFAC, as we know, provides the public with guidance about how to comply with sanctions through a variety of tools. But I would say perhaps the most well-known one is OFAC's compliance hotline. Anyone can contact the compliance hotline for help complying with OFAC-administered sanctions. And even if you wanted information about sanctions programs or guidance on OFAC procedures, or even tips on using OFAC's web resources, definitely feel free to reach out to us via the compliance hotline. On this slide here, we included the website. It should also be in the reference document. I would say because of the public's helpful feedback, especially from compliance hotline users, OFAC is in the process of transitioning from an email and telephone hotline to a single user-friendly online platform where we will receive queries, questions from the public. So the public can now submit those queries to us, those inquiries to us, and you provide us all the necessary details directly on our OFAC compliance hotline page by filling out the form you see here on the slide, the 2 screenshots. Some fields are mandatory, but it's key fields. It's a straightforward form, and you can fill this out by, like I said, visiting our website. So the website up there says ofac.treasury.gov/OFAC-compliance-hotline. It will navigate you to the web form. But let's say for some reason you're unsure of the link, or you can't find the OFAC compliance hotline, we are also in the Contact OFAC page. And the Contact OFAC page you can access from anywhere on the web page, whether at the bottom where it says Contact OFAC, or even at the top where it says Contact Us. And like I mentioned with this slide, we are in the process of decommissioning other platforms. So as you may have seen, the email account was decommissioned mid-August, and the telephone will be decommissioned at the end of the year. We made an announcement of that through our recent actions. So the best means to contact us, like I said, is the web form. I know we've given you guys a lot of information. I do see here that we may still have some time available. I have not been checking the chat, so I'm not quite sure if there's any questions pending. Brian, you let me know if there's anything pending. But if you guys do have any questions about the resources we mentioned, or even information about OFAC, please let us know, whether here during this outreach, but even reaching out to us as well.
stage so I can help you. Thank you very much, Giselle and Brian, for that information. Very, very helpful. I know there are some questions in the Q&A. Brian answered a couple of them in the chat. I don't know if you want me to read them so everyone can hear, and then you just answer verbally so everyone can hear. Would that be a good way of doing that?
Oh, yeah, certainly, Lessa. Any questions that we have pending, we're happy to answer if we're able to.
Oh, okay, thank you. And as a reminder to participants, if you do have a question for OFAC, please type them into the Q&A. We will take as many of them as time permits. There is a question that says, should every international transaction be vetted against the OFAC sanctions list? What would your recommendation be?
So I would say for this one, this is an interesting question that we also get a lot on the compliance hotline. And all to say, referring back to those 5 essential components, what is that risk, right? So if your international transactions are, I'm going to say, in a country that has no sanctions, like it's not a high risk country from OFAC's perspective, then vetting all the transactions may be a little more that the institution is taking on unnecessarily, right? Versus if those international transactions are in a high risk jurisdiction, right? So regions or jurisdictions that are ultimately blocked by OFAC sanctions, or there are prohibitions in those regions or jurisdictions, that is definitely something you would want to vet and assess in your compliance program. I would also say, more importantly, those international transactions, a key thing to play is what you know about the clients, right? The customers, the parties in the transactions. All of that are key pieces of information in what that screening process looks like. Every institution's screening process will vary across the board. But if you recall from that risk matrix that I was mentioning, if you are a well-established company with clienteles that are the same, you've collected the necessary information,
I am.
Hi, Lessa. Can you hear me?
I can hear you, but I believe Giselle froze for a moment there.
Oh, okay. Maybe let's give her a second to log back in, but what's the next question? We'll see if I can...
Sure. Thank you very much for that. We did have some technical issues yesterday. I was hoping against hope that we would go through the day without any more, but okay. There's a question that says, do you have an example of commodities that are not normally sanctioned? Are they items like food and agriculture?
Yeah, that's a very good question. I'm going to kind of go back and fall on something that I raised in the presentation, and that is that a lot of these prohibitions are very program specific, and what is included in many, but possibly not all, of our programs are general licenses that relate to agriculture, medical, and kind of some of those related transactions and goods and services. So I would, to fully answer that question, would involve being specific to the program involved and whether or not the general license is A, present, and B, if it specifically authorizes the transactions or the shipments or the imports, exports of within the context of that program.
Okay, thank you. There's a question, I'm just going to read it as it is posed. Is the non-SDN list also found on the consolidated screening list? I know you have your own search engine. Is this also a consolidated list?
That's also a great question. The short answer is yes. The longer answer is that we provide many different formats and we separately break down those different file formats available in our sanctions list search tool, our sanctions list service. We've transitioned to that now. So there's two SLSs, which can be kind of confusing, but it's our sanctions list service. And so depending on what your needs are, if you need to ingest the raw data to then employ as part of your screening program, we provide that file formatting. And we also provide, we call, human readable formats. So it's just more kind of like a PDF, and it lists all of our different sanctioned entities, as well as our and it provides separate PDFs for our non-sanctioned but still listed entities. And by that, I mean like our non-SDN list, our menu-based sanctions list, like our CMIC program that I mentioned in the presentation. So that's kind of like the lists that are available for downloading. And in addition to that, our search tool, which is now part of this list service, will search all those separate lists concurrently as you search. Sorry, I'm just going to texting Giselle so she knows that she is needs to try to log back in.
Oh, okay. Thank you very much. We appreciate that. May I continue with the questions, or would you like a minute to do that?
Go ahead.
Thank you. A slightly separate but related question. Are all sanctioned and embargoed persons, entities, and countries included when utilizing the consolidated screening list? So is this a list that can be used for all those?
Yeah, so it's also a really good question. And I would go back to something that Giselle mentioned. And the short answer is no. And the unfortunate kind of part there is the 50% ownership potential for these different entities. So even though a entity may not be directly listed on our search tool, they may be greater than 50% owned by an entity that is listed on our search tool or listed under one of our sanctioned programs, and therefore that non-listed entity would also be considered to be sanctioned. So that's why it's really important to do kind of the full due diligence required, and that is predicated on the specific risk of that business, of that transaction, of that business line, to understand the ownership and understand if that 50% rule may apply to the parties that you're involved with.
Great, thank you. And thanks for joining us again, Giselle. I apologize. We seem to be having a little bit of technical difficulties. We had some yesterday, and we're hoping that we would go through today without having any, but
no worries. I'm happy to have you back in. I wasn't sure to what extent you guys heard the response, but thank you, Brian, for being able to field the question.
Absolutely. Thank you. Okay, here's another question. We have a customer who has told us that their customer had a license with OFAC, but could not show it or prove it that they had one. They gave us the license number, and we went to OFAC license portal, and it would tell me if license was received or accepted. Based on the message accepted, does that mean we can proceed with the transaction? The final location was Venezuela. And the follow-up to that is, I'm sorry, the second part to that is, why are we as the shipper not allowed to see a copy of the license so that we know that we are compliant?
Yeah, great question on a specific license. So that's the key thing I would want to stress. A lot of times when we get inquiries like this, people are trying to check the general license. So I first want to start off with clarifying that aspect. If someone is telling you they're relying on a general license, all our general license can be found on the website, right? So you can search the sanctions program and country information page, but you can also search the Code of Federal Regulations to see, where that general license exists. So that would be to verify general licenses. To verify a specific license, the key thing I want to stress is that the applicant who submitted their application to the licensing division is the one that will receive the license when issued. If and when they receive a license that's issued, then they are able to share. OFAC would never share information about a specific license to other parties. So, for example, when they share that license with you, it's important for you to verify, am I listed in this license, right? Am I a scope of the license. Is this license pertaining to activity that this individual wants to do with me? So in all those aspects, it's essential for you to connect with the individual and say, has OFAC issued you a license? That would be the best way to verify that. Another way of verifying that is by going onto the licensing portal. On the licensing portal, instead of submitting an application, you can select the check application status. And in there, you would just type in the last few numbers of the case ID, and that would allow you to see the status. So the status would say approved and or issued, right? If the license has been approved and or issued. So keep an eye out for those statuses, because that would tell you if this process has been complete. We've gotten questions in the past where people are like, when they reach out, they say, oh, well, this institution says they already got a license from OFAC, all because they submitted a license application. Just because they submit a license application does not mean a license was issued. It may still be part of the process, and licensing does review it on a case-by-case basis. So you certainly do want to ensure that you receive the issued license, because ultimately OFAC would provide that.
Okay, thank you. There was a question earlier. I believe you mentioned it already, but it might be worth reviewing because there was a question on it. Where can I find the OFAC sanctioned country list? On the OFAC website, it says there is no list.
Yeah, so the OFAC sanctions and country program information list is on the OFAC website. I am personally going to navigate onto it just to show you guys as I tell you everything. But if you are on ofac.treasury.gov, which, like I said, is a top link that I provided in the reference document, there is on there on the left-hand side is a section called Sanctions Program and Country Information. That is part of the Sanctions Program and Country Information list. So let's say you wanted to select on Russia-related sanctions, Iran, which are one of the ones listed there. It would already bring you into the Sanctions Program and Country Information list. If for some reason you don't want to, go on to one of the listed ones, you can simply select the blue header, Sanctions Program and Country Information, and they'll populate the entire list of active sanction programs. So all of that information is listed there. What I would say is, just because it's populated as an active sanction programs, keep in mind what Brian was saying earlier in the presentation, that our prohibitions vary across the board, right? One program may be a list-based, meaning, solely focus on the SDN list and nothing more, versus another program may be on a non-SDN list or, more extensive prohibitions. So definitely just know that just because it's listed as an active sanction programs, it's key to understand what those prohibitions in that specific sanction programs entails.
Thank you. And as a reminder, you can type your questions for Giselle and Brian into the Q&A box. There is, while I'm waiting for additional questions to come in, there was a question earlier that Brian answered. I'm just going to read the question and the answer so that all the participants can hear it. The question is, what does a company do if they are owed money from a company that is sanctioned financially? And the answer from Brian is, Giselle had mentioned that you can apply for a specific license from OFAC to request authorization for specific activity with a sanctioned entity or jurisdiction.
Absolutely. And just to supplement that, I would say if you're looking to engage in any activity that deals with blocked property, meaning property that was reported to OFAC, so goods that have been blocked or blocked funds, or if you're looking to engage in a transaction with a blocked individual, the key thing is you would need to seek authorization from OFAC. I'm not telling you the authorization will be granted, right? OFAC reviews those applications on a case-by-case basis, but because it is prohibited activity, an authorization from OFAC is needed. And while we're waiting for other questions, I also do want to share one additional link that is part of our recent actions. So like I said, if you are not signed up to our recent actions and you're on OFAC's page, on the left-hand side, there's a recent actions tab. It allows you to receive real-time notification of these updates. For example, we just issued an advisory. So if there's a new case enforcement action release, that would be posted there so you can review review that compliance consideration sections. But the link I'm sharing is one of our newer links about OFAC's website. It's a survey that has been created, and this action went out on October 11th. And it's basically looking for feedback from the public with regard to enhancing our sanctions information, being able to improve, user experience on the website, and what new features you're looking for OFAC to provide. Right, like I mentioned, we are doing this modernization effort of the video series and the FAQs. So if you're looking for some additional guidance or even clarity on the guidance we have, or if something's confusing, please feel free to use this survey to share your feedback about OFAC's website. Our developers are looking into it, and like I said, more is in the works for that. So definitely please refer to that survey.
Great, thank you very much. There is one question that came in. It's more of a process improvement question. It seems OFAC has a lot of information available for companies to use. Is there any tool or APIs a company can use to help automate some of the information they would need to gather?
Great question. So on the resource document I provided, one of the newer tools that OFAC has issued is our SLS application. So basically, this is a new means of a sanctions list service application. It's one of those modernization efforts where now you can download different customized files of the various sanctions lists. So for automated or batch functionality or searches, you can certainly integrate that into your internal controls through the SLS application, so sanctions list service application. You can see once you're on that page, you'll see that it breaks it down from SDN lists or consolidated lists, and you can also even have customized data sets. But more importantly, also sometimes people are like, "What about archived records?" Right? So there is on that new application archive records, right? So to help you track when things have changed, for example, an individual being placed on the list versus when they were removed. So the archive records can help facilitate that. So I would definitely say for API search functionalities, definitely the SLS sanctions list service application is your resource. As for our other guidance information, staying up to date through recent actions may be a means of you maintaining up-to-date information and being able to adjust rapidly to change. So on the recent actions page, you can also sign up to receive those recent actions, like I said, in real time. So if you have, for example, if part of your job entails, updating the sanctions compliant program or being aware of these, fast changing sanction programs that roll out, that would be one means of being able to get the information in real time.
Great, thank you very much. And I will pose just one question unless any additional ones come in. This was one from earlier today. I just wanted to see if you have any additional information to add. It pertained to documents that need to be filed for vessels carrying and bringing cargo to sanctioned countries like Cuba, if OFAC would have any role in that.
So for that, I would say to look at our reporting requirements, right? Certain general licenses in the Cuba sanctions program may require certain reporting functionalities, whether quarterly reporting. So if you're relying for any reason on a Cuban general license or even specific licenses may request reports, then I would say look at reporting requirements. The other key thing that I mentioned is any type of transactions or activities. There is a reporting, a record keeping requirement. So maintaining records for the purpose of retaining the records, but also in an event, let's say there was an enforcement action, you would have that information is key. So the records keeping requirement plays a part in what that document collection looks at. So definitely look at our RPPR. So that's our record keeping and reporting regulations to better understand what that may look like. But specifically for programs, I would say look at the general licenses to see is there a reporting requirement and what reports should be provided to OFAC. Sometimes the reports don't even need to come to us. I know some general license, for example, may request reports going to State Department. So understanding the general license, understanding what that report is and who the report ultimately has to go to is key.
Okay, thank you very much. And with that, we've hit the 4 p.m. mark. We do appreciate you taking the time to present today. We had a really good group on the line. We please note in the chat, Giselle has dropped a link there to recent actions for your review. Now we will go to our Q&A session, but feel free, Giselle and Brian, to drop off if you'd like to stay with us. You're welcome to do so. If you have to drop off, we understand. This is just a session for additional questions that we didn't get to earlier today. So thank you very much again for being with us. We appreciate it very much. You're muted. Sorry.
Thanks, Lessa. I said thank you for having us. We're always delighted to come back to these events and just give, like I said, background on OFAC and help industry members better understand what those requirements are when it comes to OFAC and sanctions compliance when looking at OFAC sanctions. We won't be able to stay for the rest of the time, but if you have any additional questions, please certainly do reach out to us. The compliance hotline, like I said, is your best means of contacting us. The link is provided in the reference document, so you can always have a follow-up question or even a specific question about activity. We're more than happy to answer. But thank you.
Great. Thank you very much. Have a great afternoon.
You too.
Thank you. Okay, and now we will go back to some of the questions in the Q&A. I see that James and Becky have joined us. So, James, I have been reading the questions and, having the presenters give the answers verbally so that all can hear. I don't know if that's a good format for you. I'd be happy to continue that.
Yeah, I have the questions here written down with me. I could go through the ones that I saw.
Okay, we can do that as well. Please go ahead.
So the first question here is BIS planning any updates to their website to make the EAR Part 744, I think they mean 774 in the Commerce Country Chart, easier to read? We're working on that now. We have the contractors trying to make the website more user-friendly. I would encourage folks to go to the website and make a comment. That's going to be helpful. But the contractors are working on that now. Next question: if a reseller is selling encrypted radios and the manufacturer holds the license, is this sufficient? What action must the seller receiving payment take to document/confirm a license and/or file the EEI? So the licenses, it's important to remember, are transaction-based. The actual exporter needs to obtain the license if a license is required for that transaction. A quick example would be if I bought an iPhone from Apple, and then I'm going to resell that iPhone abroad. I would have to apply for the export license if that transaction required the license. How often should you get formal classification of EAR 99 items? If you receive formal EAR 99 classification through SNAP-R, then do I need to have formal classification again? 5 years, 10 years? But the classification rarely changes. If the technical parameters of the items change, then I would say come in for a commodity classification request if you can't confidently self-classify. If you have a commodity classification request and you have an ECCN number from the department, at the time that you receive that commodity classification determination, you really should copy that ECCN, file it away, and see if the ECCN ever changes when you go to ship in the future. That's an important part of compliance, I would say. For next question is, for items that are not on the CCL, is it accurate to refer to them as NLR, no license required, rather than EAR 99? Is that correct? That's a big no. EAR 99 items could require a license. It's based on the end use controls, and there are some the embargo destinations, where there could be licensing requirements for all EAR 99 items, excluding, say, food or medicine, for example. If you look at the Russia-Belarus sanctions, we incorporated a lot of HTS codes into our regulations, and a lot of those items are EAR 99 items, but it's based on what they are, would require the license that to those destinations. So just keep that in mind. To export technology as cell phones or computers, what will be the correct process? Well, you've got to determine, go through the order of review, determine what the ECCN number would be for those items, see if you have a licensing requirement based on the ECCN number and the destination, and whether or not there are end use restrictions that might come into play. But you've got to first properly classify those items. Next question would be documents that need to be filed for a vessel carrying and bringing cargo to a sanctioned country like Cuba. There are Cuba-specific FAQs on our website. Just for the vessel, they would most probably be eligible for the AVS, aircraft, vessels, and spacecraft license exception. You want to look at those FAQs and see if that applies to the transaction. It would be important to remember that the cargo transported by the vessel may require a BIS authorization. For Cuba, most certainly would. And if it's just the vessel, you'd want to look into the exemptions from the EI filing requirements. There, 15 CFR 30.35 through 30.40 of the FTR would have those exemptions. The next question: are all sanctioned and embargoed persons, entities, and countries included when utilizing the consolidated screening list? So the countries are in 746. The end user and use controls are in part 744. You also don't want to forget to screen your activity. As you know, your activity could trigger a licensing requirement. EE has a lot of good resources as well. If you go to our homepage and you look for the enforcement drop-down menu and you click on About Export Enforcement and you scroll down toward the bottom of the page, there's a link to the enforcement policy memos and industry guidance. You would click on See Policy Memos, and there's a boatload of guidance there that will help you with your compliance. Is there an email we can use to send questions to the encryption hotline? There's not an email just for the encryption folks. There's a life hack, though. If you do go to our website and you go to can't find what you're looking for under the quick links section, and you scroll down toward the bottom, try to find the guidance policies. If you click on the View Guidance Policy FAQs, I know this is complicated. It'll take you to the old site. You want to really get back to the old site because this hasn't all been moved over yet. And if you look for the Policy Guidance drop-down menu there's a section for encryption and export administration regulations, and there's a Contact Us section in that drop-down menu. It's a drop-down and a pop-out menu. And the email information for some of the licensing officers are there, so you could email them directly. And the next question here is, does the license devalue at the time of the AES filing or at a different time? As far as I know, when you make the ACE filing, then it decrements. You had 10 things, you file that you're shipping 5 things. Now you want to think of it as having only 5 things left, if that makes sense. I don't know how long. I think the person probably is wondering, if I make the filing and I don't ship, what happens? How do I amend it? I'm sure someone from the Census Bureau could answer that question. How often are license exceptions and controls updated? There's really no set agenda. This last year was pretty active. Just keep looking at the website for any updates. You know, we announce things there, new license exceptions, things like that. They'll be right on the homepage. If an item is not subject to the EAR, do we just leave that field blank in our commercial paperwork, or is there an exception number we should put in there? If it's not subject, it's not subject. You wouldn't require the license, or you wouldn't require. It wouldn't have an ECCN number. So there wouldn't be anything there. You'd be no license required if it's not subject at all. When should we ask for a BIS 711 to be filled out? That's never required as a support document up front. That it's for the applicant's convenience for the most part, and to help confirm that all the due diligence information was gathered. If you're an applicant and the LO the licensing officer asks you for it, then the information becomes required information under the EAR. It's a nice thing to have to ask for if you're applying for the license. If you already have it ready to go as one of your support documents, could save you some time. We had a question about license exception GOV. Question about regarding license exception GOV. When shipping Series 600 items to a private company, who is the prime contractor? Who is a prime contractor with the NATO government? Can you use the GOV exception if the purchaser is a private entity that has a contract with the NATO government and the NATO government is the end use? Is it just that you, the exporter, is a subcontract and you are sending the part to the prime contractor for ultimate end use of the NATO government? Does Gov exception apply? Or a better way to word it would be, would it be available for my particular transaction? I would send us an email if you're thinking about a specific transaction. If you've got one in mind, send it to our exporter counseling inbox. We can take a look at that or give you a call back. Potentially something like this is probably you're looking more to see if STA would be available if it's a government end user in the other country for a Series 600 item. That's looks like that might be more applicable for this type of a transaction, the STA license exception. Read about the requirements for the Series 600 items there. Someone asked, can you expand on the difference between ultimate consignee and end user? For example, aircraft parts sold to a repair shop to be installed onto an aircraft, but the shop does not operate the aircraft. I would just point folks to the definitions of end user, intermediate consignee, ultimate consignee, and principal parties and interest in 772, the regulations. The end user, you want to think of the end user as the person abroad that receives and ultimately uses the exported or re-exported items. The end user is not a forwarding agent or an intermediary, but may be the purchaser or the ultimate consignee. The ultimate consignee, you want to think of them as the principal party in interest located abroad who receives the exported or re-exported items. The ultimate consignee is not a forwarding agent or other intermediary, but might be the end user. You wouldn't necessarily have multiple end users in every license. You might just have an applicant and an ultimate consignee. And the intermediate consignee is the person that acts as an agent for the principal party in interest for the purpose of effecting delivery of items to the ultimate consignee. And principal parties in interest are those persons in a transaction that receive the primary benefit, monetary or otherwise, of the transaction. So generally, those principals in a transaction are the seller and the buyer in most cases. When applying for a bulk license, is it necessary to include a specific purchaser? There may be cases where the purchaser changes over the license's duration. For example, certain line items may be purchased by different domestic or international buyers, while others are acquired directly by the international end user. Additionally, a party may own multiple companies / entities for purchasing. Please advise. So remember, the licenses are transaction-based, so they the bulk licenses authorize the export or re-export of items based on a representative list of items. An applicant that regularly supplies parts and components to a single buyer that's key for one or more platforms might benefit from a bulk license. So it's the single buyer. If you have a different ultimate consignee or end user, you want to apply for a separate bulk license for that transaction. And when you apply for, the licensing officers will work with you on the bulk license applications. You'd submit a representative list of parts, the platforms or systems you're supporting, the part numbers or stock numbers, technical descriptions, ECCNs for each part, and they'll structure that license to meet your needs. Those are the only questions that I saw there. If there are additional ones, you can let me know.
Great. Thank you, James. There are a couple others, but before I pose them, just a reminder that Becky Hint from DDTC is also here if you have any ITAR related questions. There's a question here. AES direct filing, would it give you an error message if it does need a license? Do you know that?
If there's someone here from Census, maybe that'd be better suited to answer the AES specific questions, like the system questions.
Okay, so I will forward that over to Census for their review. For shipments heading into Canada, special permit is required for shipping ammunition. Does it have to be labeled on the outside of the package, or is that not required because ammunition is technically not hazmat?
Yeah, I'm not sure if that's necessarily a question for me. If you're shipping ammunition to Canada, did it have the license requirement there to begin? Sometimes you could use, I think on occasion you could use STA potentially for ammunition. I'd have to look into that. You want to look into your specific transaction, but I wouldn't be able to speak to the labeling.
Yeah. Hey, James. Just again, this is somewhat anecdotal because it's been a couple of years since my office has controlled most ammunition to Canada, but I think that this questioner is actually asking about a specifically Canadian requirement, not a US-based requirement, and it has to do with Canada's import laws. So that would actually be more of a question for the Canadian government than us.
Okay. Yeah, always check with the Mounties. See what the requirements would be there.
Thank you. I'm not sure if this is yours, James. On the 7-Eleven, the exporter wants to have their CYA document if asked by CBP, BIS, etc. Not even sure that's a
I'm not
question.
really sure with that. It wouldn't hurt to have a 7-Eleven.
Okay. There are some others on there. It's will all agencies move to 10-year record keeping from 5 years?
I'm not aware of any plans for that.
Nor am I.
Okay. And there was a clarifier to the Canadian question that says, thanks, the requirements are always interconnected, BIS, AES, Canadian imports, PHMSA. Okay, I don't see any other questions here. The others are mostly comments. So I think we will conclude today's event with that. I want to thank all our presenters again. We really appreciate you making this such a success for our companies. We want to be sure that they are compliant with all the regulations and the agencies involved in their export business. So we thank you for joining us for this event. Thank you to our participants for staying engaged and for staying with us through 2 days of information. We hope that the information that you received was very helpful, very useful to you, and will help you to stay out of trouble and keep compliant. We promised that we would have a gift ready for someone who has stayed with us and stayed engaged. We randomly selected Eleanor Nasal. I'm not sure I'm pronouncing that correctly, for a gift card from us. Congratulations, Eleanor. Thank you for being with us. And we will send that gift card over to your email address. So this concludes today's presentation. We look forward to having you join us again next year when we bring you this seminar, as well as any updates on the regulations. Appreciate it. Thank you and have a great day.